क्रिमिनल लॉज को बदलकर, आपराधिक कानूनों को बदलकर उनकी जगह पर नए कानून लागू किए जा रहे हैं। और इनमें से 2 कानून तो 1860 और 1872 के, तो आप समझ सकते हैं कि इस बीच में परिदृश्य कितना बदला है, दुनिया कितनी बदली है, तकनीक कितना बदला है। निश्चित रूप से न्याय प्रणाली को, न्याय व्यवस्था को बदली हुई आवश्यकताओं के अनुरूप खुद को ढालने की आवश्यकता है। कई सारे मामलों में माननीय उच्चतम न्यायालय ने अपने विभिन्न आदेशों के द्वारा भी वो प्रावधान किए थे जो कि मूल हमारे जो एक्ट हैं उनमें उपलब्ध नहीं थे। मुझे खुशी है कि नए एक्ट में अब इन सब बातों का प्रावधान कर दिया गया है। पूर्व में आपराधिक मामलों की जांच पड़ताल में व्यक्ति आधारित साक्ष्यों की प्रधानता थी, लेकिन वर्तमान समय में तकनीक को अपराध अनुसंधान का बहुत ही महत्वपूर्ण अंग माना गया है। इसमें दोनों पक्षों पर कार्य किया गया है। अनुसंधान को कैसे हम तकनीक का इस्तेमाल कर बेहतर कर सकें, अनुसंधान का एक अंग जो है FSL, विधि विज्ञान प्रयोगशाला, उसको कैसे हम बेहतर तरीके से बनाकर उसका बेहतर से बेहतर उपयोग कर साइंटिफिक तरीके से इन्वेस्टिगेशन कर सकें। और वहीं जो जजमेंट देने की प्रणाली है उसके लिए कोर्ट्स का जो पूरा तंत्र है उसमें स्टेटमेंट, अटेंडेंस, रिकॉर्ड, FIR, ये सब मुझे लगता है कि बहुत ही आमूल-चूल परिवर्तन किया गया है। इसमें 0 FIR का भी प्रावधान है, जिसमें कुछ खास तरीके की घटनाओं में कहीं भी FIR लिखाई जा सकती है यदि घटना स्थल स्पष्ट ना हो। वीडियो रिकॉर्डिंग इत्यादि को अनिवार्य अंग बनाया गया है। प्रावधान किया गया है कि जैसे ही इन्वेस्टिगेशन ऑफिसर अपने साक्ष्यों को इकट्ठा करते हैं, वो साथ ही साथ उसे संबंधित पोर्टल पर डालते चलें और वो बिना किसी विलंब के न्यायालय को उपलब्ध हो। इस नए कानून की बारीकियों को जानने के लिए 2 दिनों में हम लगातार चर्चा करेंगे विभिन्न विषयों पर। कल के प्रारंभिक सत्रों के बाद एक ओपन हाउस सेशन भी रखा गया है। मैं आप सभी से अनुरोध करूंगा कि आपके अपने जो भी इसके संबंध में डाउट्स हों, संशय हों, उनको जरूर आप दूर कर लें, उन पर जरूर आप पूछें। हमारे सभी विद्वान वक्तागण यहाँ उपलब्ध रहेंगे। एक बात की ओर मैं और आपका ध्यान आकृष्ट करना चाहूँगा। नए कानूनों एवं नई व्यवस्था के आने से मैं उम्मीद करता हूँ कि आने वाले समय में अब हमारे कांड उतने लंबित नहीं रहेंगे जितने अभी लंबित रह रहे हैं। इसमें दोनों तरीके के हैं, जो इन्वेस्टिगेशन के लिए लंबित हैं और जो ट्रायल के लिए लंबित हैं। ट्रायल के लिए आज की तारीख में 16,80,000 वाद लंबित हैं। ये अलग अलग स्तरों पर लंबित हैं। इसमें सभी जिला एवं सत्र न्यायाधीश का, मुख्य न्यायिक दंडाधिकारियों का, जिला पदाधिकारियों का, पुलिस अधीक्षकों का एवं जिला अभियोजन पदाधिकारियों की बहुत ही महत्वपूर्ण भूमिका है। मैं अनुरोध करूंगा कि एक कार्य योजना बनाकर आपकी जो जिला स्तरीय मॉनिटरिंग कमेटी होती है डिस्ट्रिक्ट जज की अध्यक्षता में, उसमें इसका सतत अनुश्रवण करें। इसकी मासिक तौर पर बैठक होती है और मुझे खुशी है कि यह बैठक लगातार हो रही है। तो मैं चाहूँगा कि इसमें लगातार इसका अनुश्रवण किया जाए और पुरानी लेगेसी को हम दूर करने का प्रयास करें। इसको हम यह प्रयास करें कि इन वादों का निस्तार किया जा सके। मुझे पूरा यकीन है कि इस 2 दिनों की कार्यशाला से आप लाभान्वित होंगे और हम सब इस कार्यशाला के उपरांत इन नए कानूनों के संबंध में और भी बेहतर तरीके से जान सकेंगे। धन्यवाद।
बहुत बहुत धन्यवाद, आभार व्यक्त करती हूँ हमारे प्रधान सचिव गृह विभाग श्री अरविंद कुमार चौधरी सर का, जिन्होंने सभी का स्वागत करने के साथ साथ इस कार्यक्रम का आयोजन के प्रति क्या उद्देश्य है इसके बारे में भी सर ने बताई और रूपरेखा। थैंक यू सो मच सर। और अब मैं एड्रेस के लिए संबोधन हेतु सादर निवेदन करूंगी हमारे डीजीपी बिहार श्री आर.एस. भट्टी सर।
Honorable Mr. Justice K. Vinod Chandran, the Chief Justice of Patna High Court, Honorable Mr. Justice Ashutosh Kumar, Honorable Mr. Justice Joy Malya Bagchi of the Calcutta High Court, Honorable Judges of the Patna High Court, Learned Advocate General Shri P.K. Shahi, Development Commissioner Bihar Shri Chaitanya Prasad, Principal Secretary Home Shri Arvind Kumar Chaudhary, Senior Advocate of Kerala High Court Shri B.G. Harendranath, Assistant Professor Neeraj Tiwari of NLU Delhi, Senior IPS Officers of the Police Headquarters, Divisional Commissioners, Zonal IGs, DIGs, District Judges, District Magistrates, Superintendents of Police, District Prosecution Officers, Chief Judicial Magistrates, distinguished guests, ladies and gentlemen. At the outset, I extend a very warm welcome to all the participants of this two-day workshop. As you will recall, one workshop was held before the laws were implemented, and that interaction, I'm sure, helped you have the basic understanding before the rollout of the laws. This is the second opportunity, and you have an experience of about a month in which you will have more hands-on discussions amongst yourself to get a sense of what are the problems, what are the issues that are coming up. And I would advise you, request you to not only discuss it during the various lecture sessions, but also amongst you, because you are the implementers of these provisions on the ground. And a lot of feedback from you will also help us, will also help the honorable judges to understand the ground reality better. As you all know that we are fully determined to make sure that these laws are rolled out effectively. From the side of the police, we have taken very effective steps, starting with a training, a hybrid mode training in which 25,000 investigating officers were trained in a period of less than 1 month, based on a very carefully prepared study material that was circulated in advance, and even the script and the lectures were standardized to ensure uniformity of training. And the training did not only cover understanding of the new laws, it also covered the digital investigation aspects. In fact, we issued a police order, a detailed police order, to make sure that the digital evidence is properly collected and sort of added to the charge sheet and placed before the honorable courts for consideration. We also gave hands-on training to the officers on the CCTNS, the Criminal Crime Tracking Network System, which is linked to the ICJS. I'm happy to share that for a long time there were some issues with the CCTNS. We have overcome that, and now we are, I think, almost connected with the ICJS network. And the judicial officers who are coming from the field, in case they have checked up, many of the FIRs would now be, I think, seamlessly integrated in most places. And you can see the FIR from there rather than the physical copies. Very little work remains left in a seamless integration of the whole ICJS system. That will be a very big landmark in terms of ensuring the kind of expectations that these laws have. It's essentially about a digital investigation system, a digital trial system. So that CCTNS network, and we are also at very advanced stages of approval of the competent authority for giving a smartphone and a laptop to every investigating officer of Bihar Police, who will be trained in that, to make sure that the reality of an EFIR, an E-investigation, an E-charge sheet is there for everyone to experience. And one more thing I would like to add, that the process of this rollout, when the new law started, I happened to visit and interact with the Director General NCRB, and I'm happy to share that he said Bihar was one of the best in terms of a very smooth rollout, because we could integrate the FIRs with the CCTNS system, and we have ensured that the relevant forms which need to be linked up with the CCTNS system, they are working effectively. Our officers, whatever difficulties, initial hiccups, we have sorted them out. I look forward to a very vibrant workshop in which all of you contribute to making this legal framework effectively work on the ground. And we will look forward to your feedback, your suggestions, and I'm sure that together on the ground we can do a much better job, and people will get a more faster, a more people-friendly judicial system. Thank you.
Thank you so much, sir. Our Honorable DGP Bihar, Shri R.S. Bhatti, sir, for addressing us in this historical event. Thank you so much, sir. And for address, now I would like to request our Development Commissioner of Bihar, who is in charge of Chief Secretary of Bihar also, Shri Chaitanya Prasad, sir.
Honorable Mr. Justice K.V. Chandran, the Chief Justice, Patna High Court, Honorable Mr. Justice Ashutosh Kumar, Honorable Mr. Justice Joy Malia Bakshi of the Calcutta High Court, Shri Prashant Kumar Shahi, Learned Advocate General Bihar, Shri B.G. Harindranath, Senior Advocate, Shri Rajvinder Singh Bhatti, Director General of Police Bihar, Shri Arvind Kumar Chaudhary, Principal Secretary, Home Department, Shri Neeraj Tiwari, Assistant Professor, NLU, Delhi, Honorable Judges of the Patna High Court, the learned District Judges, District Magistrates, SPs, Senior SPs, CJMs, learned Public Prosecutors, Senior Officers of the State Government, of the Police. At the outset, let me welcome all of you to this conference. The rapid economic development in our country and the emergence of new technology and its adoption by Indian society has clearly reflected positive results in our social and economic systems. But as a result of these advancements, with the advent of new technology and development in all sections of the society, there has been a change in the dimensions of crime, and some crimes which were not prevalent earlier have come up now and have seen an unexpected rise. For example, we can see the increase in the number of cyber crimes and in economic crimes. The adverse effects of such new crimes not only fall on a particular person or an organization, but it also affects national security. New technology is also being used by organized criminal gangs and anti-national organizations to achieve their illegal objectives, which is posing a big challenge to the law enforcement agencies. The old laws seemed inadequate to face these new challenges and provide justice to all sections of the society. And in order to provide adequate legal basis to law enforcement agencies to face these new challenges and to control effectively, the Bharatiya Nyaya Sanhita 2023, the Bharatiya Nagrik Suraksha Sanhita 2023, and the Bharatiya Sakshya Adhiniyam have been enacted in place of the IPC, CRPC, and the Indian Evidence Act. These acts have been enacted to provide a strong, modern, and scientific basis to the criminal justice system, to bring transparency in the legal provisions, and to improve the quality of investigation with the help of technology and forensics, and to set time limits in various processes, so as to improve the conviction rate in criminal cases and to ensure justice to the victims within prescribed time limits. The new laws provide that now a person can report occurrences through electronic means without going to the police station physically. This makes reporting of cases easier and quicker and facilitates the police also to take prompt action. Zero FIR has been introduced. Now any person can file a first information report at any police station regardless of jurisdiction. This will eliminate delays in initiating legal action and ensure immediate reporting of crime. The use of interoperable criminal justice system will also prove to be very helpful in this direction. ICJS aims to provide a seamless transfer of data and information among the various pillars of the criminal justice system, which includes the police, the prosecution, the courts, the prison and forensic science. And by use of these information and data by the courts as well as law enforcement agencies, speedier justice can be provided to all sections of society and the rule of law can be established more effectively. It can be an effective tool, the ICJS, for case and court management, as all the relevant information of a case will be available in real-time basis for use by the courts. The executive officers, executive magistracy, have also been given powers and responsibility under these new acts as well as under other acts. For example, if any crime is committed against a person belonging to the scheduled caste or scheduled tribe, it is the duty of the officials posted at local level not only to provide them security, but also to provide financial assistance immediately. To prevent recurrence of such incidences, the executive officers have been given authority to take action against antisocial elements in these cases. It is expected that the laws, rules and schemes made by the state government, particularly the witness protection scheme, will be implemented on the ground effectively by all administrative and law enforcement officers to bring speedier justice to everyone, especially the scheduled caste, the scheduled tribes, the weaker sections of the society, as well as to the victims of crime. It is the priority of the state government to not only punish the guilty, but provide justice to all sections of society. Also to strengthen the sense of security and respect for rule of law among them, for which it is essential that the police, prosecution, courts and prison administration must take coordinated efforts. These new laws make it mandatory for forensic experts to visit the scene of crime and to collect evidence in heinous crimes to strengthen the case and investigation. Apart from this, to prevent tampering with evidence, a provision has been made to make videography mandatory so that the process of collection of evidence is videographed. This will boost quality and credibility of investigation significantly and contribute to fair and impartial administration of justice. In the formulation of these acts, humanitarian aspects have also been incorporated so that easy and accessible justice can be ensured expeditiously to all sections of society, particularly to the weaker sections. Besides, the faith of the people in the rule of law has to be strengthened. Adequate care has to be taken for the rights of the accused so that any innocent person can get prompt legal protection and justice. Intrinsic to the new laws is the common thread that all stakeholders in the system of administration of justice, along with law enforcement agencies, should act efficiently to provide justice to the common man and avoid delays in the delivery of justice, thereby reducing pendencies of litigations. I hope this workshop shall act as a milestone towards effective and efficient administration of justice, ensuring speedier and easier justice to the common man. And I hope that there is full participation in this workshop so that all of us gain out of it and in the end the common man gains out of it. Thank you.
Thank you so much, sir. Our Development Commissioner of Bihar, Shri Chaitanya Prasad, sir, and he's also in charge of our Chief Secretary, Bihar. So thank you so much, sir. And now, our next honorable speaker is Advocate General Shri Prashant Kumar Shahi. Advocate Prashant Kumar Shahi has also been the Advocate General of Bihar in the past from 2005 to 2010. He was the Advocate General of the state government. He was also beat Education Minister in Nitish government. After stepping down from the post of minister, he again started practicing in the Patna High Court.
Good morning, everybody. Honorable Mr. Justice K. Vinod Chandran, Chief Justice of Patna High Court, Honorable Justice Ashutosh Kumar, Honorable Justice Joy Malya Bagchi, Judge of Kolkata High Court, Honorable Judges of Patna High Court, Mr. Chaitanya Prasad, Acting Chief Secretary, Government of Bihar, Mr. Rajvind Singh Bhatti, Director General of Police, Bihar, Mr. B.G. Harindranath, learned Senior Advocate from Kerala, Mr. Arvind Kumar Chaudhary, Principal Secretary, Home Department, Mr. Neeraj Tiwari, an academician from NLU Delhi, senior officials from Home Department, all senior police officers, learned district judges, district magistrates, superintendent of police, public prosecutors, district prosecution officers, distinguished guests and friends from media. Today, in a series, this is second such exercise, and I am thankful on behalf of the state government and on my behalf to Honorable Chief Justice, who has been guiding this program throughout, and due to his guidance, this has been successful. We conducted an introductory session even before the Act had become enforceable with effect from 1st July 2024. It was not yet implemented. Now today's workshop will have at least some experience of how the new laws are being implemented at ground level. There is a general perception amongst people, including members of bar, that these new laws are nothing new but only renumbering and paraphrasing of the old laws. They are wholly mistaken. If the three laws are examined, there is a paradigm change, not only in the sections, but the manner in which an investigation has to be carried out, the method of conducting trial, use of electronic evidence, scientific investigation. All these aspects have been introduced. Some new offences have been added. Punishments have been either reduced or increased. And particularly in BNSS, there are a lot of changes. So the conception or rather misconception about no major changes being made needs to be dispelled. The BNSS, if one scrutinizes, will find, starting from registration of FIR, 0 FIR can be registered. There is a provision that an information can be sent electronically. However, the requirement is that within 3 days, the maker is required to sign. There should not be any confusion amongst the investigators that if the informant does not sign within 3 days as mandated, then he should sit idle and wait for that person to sign and then only proceed with the investigation. This is a grey area which will have to be worked out in course of experience which the investigators will gain. The general understanding is that once an electronic information is received and the transmitter has not signed within 3 days, therefore they will not proceed with investigation. That is a misconceived notion about the provision. Now there are other changes, like 173 provides that in certain offences there has to be a preliminary inquiry, and then only further investigation would be carried out. And in that, the word used is prima facie. Now, prima facie, as understood in legal parlance in a trial and an investigation, are two different connotations. The police investigator should not be under an impression that the prima facie standard of prima facie case is the same which is before a trial court. They have a different parameters of adjudging prima facie case. Similarly, there are complete change in the method of investigation. Now, no sooner an investigation starts, forensic investigation, forensic tools have to be immediately deployed. We may have difficulty because there is dearth of, or rather forensic experts are rarely to be found, few forensic experts. There is only one university in India, in Gujarat, which is having curriculum in forensic science. In other states, they are yet to develop. Therefore, finding forensic expert may take some time. Honorable Chief Justice is sitting here. He is also Chancellor of Chanakya National Law University. It would be my earnest request that Chanakya National Law University should immediately commence a curriculum in forensic science. And if that could be possible in other government colleges and other private colleges could be encouraged to start that, then perhaps in next couple of years, the gap can be thought to be filled up. Because there is a mandate that in every investigation, now it should be done with the aid of forensic methodology. And unless we have experts in forensic science, it will be difficult to accomplish the requirement. Similarly, every investigation, particularly arrest, search and seizure, recording of statement of witnesses, all these are to be videographed. There is a positive side of it, that there would be no scope for manipulations. The statement, even a statement under previously known section 161 has also to be videographed. Now there would be difficulty for that maker of a statement under 161, the erstwhile CRPC, to change his stance. Similarly, an investigator would have no play in manipulating the course of investigation and writing the case diary as he chooses to. There is another requirement that every day the IO will have to upload the progress of the investigation. The Act has made investigation to be victim-centric. The victim or the informant will have to be kept informed of the progress of investigation by the investigator. At the end of the investigation, he will have to be informed, and mandatorily police papers for victim have to be furnished in the court to be made available to the victim. So these are very major changes which will have to be taken care of while conducting investigations. There is simultaneously timeline has to be strictly adhered to both for investigators and for the trial courts. Charge has to be framed within a certain stipulated time. Then trial has to commence within certain fixed time. On conclusion of trial, judgment has to be delivered within a stipulated period. So both investigation and trial are mandated to be carried out in a time-bound manner. Otherwise, our experience is that Article 21, the mandate of Article 21 has been a far cry to be achieved. Trial investigation itself takes years and years, and thereafter the trial drags on for one doesn't know how many years or rather decades. The objective of a speedy trial we must confess that have not been achieved. The effort is to achieve that, to reach to that objective. So these are some of the major changes. Again, similarly in IPC, rape with a victim below 18 years and above 18 years, that has been reclassified. Separate punishments have been prescribed. These are vital changes. I would not be dwelling in detail. There are distinguished speakers today and tomorrow who would be dealing at length about the changes, its implications, and how to go about it in implementing those amendments. I hope that the three new laws will enable a speedy investigation with in fair and transparent manner, and a speedy trial, so that the cases do not keep dragging on for decades as has been in the past. Similarly, Evidence Act, there are a lot of changes which will expedite the trial, not only on the criminal side, but also civil side. Because everybody knows that suits are pending for, one doesn't know. I mean, there are many factors, not only that the erstwhile laws were responsible for delay. There are many factors. The judge population ratio is disproportionately skewed. Judge, I was just discussing, any judge of Honorable Patna High Court has about 10,000 cases in this board. So these are factors, of course, they will also have to be addressed. However, these laws have a sense of priority for expediting disposal of cases, and I hope that we will be successful. It's heartening that the state of Bihar has taken lead. It has, even before 1st of July 2024, the police directorate has taken number of steps so that the rollout is smooth and there are no hiccups. And to a large extent, they have been successful. Government is committed to provide them all infrastructure. We hope that there would be no hurdle in implementation of these laws. With this, I thank all of you present on the dais and present in the hall. Thank you very much.
Thank you so much, sir, for your valuable insights about today's topic, New Criminal Major Acts 2023. Honorable Advocate General Shri P.K. Shahi, sir. Thank you so much, sir. Justice Ashutosh Kumar. Enrolled as an advocate on 9th July 1991 at Patna High Court, as an advocate, Justice Kumar has appeared in important criminal matters, including matters related to convicts on death row. He was a government pleader for the state of Bihar for a short period. He has been elevated as a judge of Patna High Court on 15th May 2014. He was transferred to Delhi High Court on 7th January 2015 and was repatriated again at Patna High Court on 24th November 2017. I would like to request to address Justice Ashutosh Kumar, sir.
Thank you very much, Soma. A very good morning to all of you. Honorable the Chief Justice, my dear brothers on bench, Honorable Justice Joymala Bagchi from Calcutta High Court, the learned Advocate General, Sri Sahi, Mr. B.G. Harindranath, Senior Advocate from Kerala High Court, Sri Chaitanya Prasad, Development Commissioner, Bihar, Mr. R.S. Bhatti, DGP, Bihar, Sri Arvind Chaudhary, Principal Secretary, Home Department, Government of Bihar, and Neeraj Tiwari, Assistant Professor, NLU, and everybody in this hall. I'm really delighted at the efforts of the government in organizing this 2 days workshop on the 3 major criminal laws. I refer to it as 3 major criminal laws for the reason that some of you find the names of the laws, the appellation, to be tongue twisters. Doesn't matter. If you use the abbreviation, I think it's as easy as CRPC, IPC, and the IEA. So it's just a matter of getting used to. See, evolution is the way of life. And change is always painful, not easy to accept, not easy to accommodate in your life. But then on ultimate analysis, it has always proved to be good for the benefit of the system where the change has been brought about. Well, all the speakers have spoken about various provisions in the procedure code, the substantive law and the Evidence Act, and the changes which have been brought about. I would not take you to all that for the reason that for that purpose, very able speakers have been requested. My brother Jaimala, Justice Mr. Harindranath, and Neeraj, of course, who does it every day. He tells his students where are the changes, what should be focused. My endeavor here would be to let you all know that this change is because of the experience that we have gained over the 100 years, and why this change is necessary and how it would affect each of the stakeholders of the justice system. That's important because in ultimate analysis you would find that most of the stakeholders would be impacted by these changes. One of my friends, Mr. D.P. Singh, who has attained a celebrity status as a prosecutor, he has written a book, My Experience and Ways Forward in the Criminal Justice System. In that book, he has identified 9 stakeholders of the justice system. They are the accused and their families, the victim and their families, the society in general, investigators, it could be police investigation or investigation by any other agency, judges, public prosecutors, lawyers, jails and jail staff, and press and media. See, it's important to know who all are stakeholders and how they are impacted by the new laws. So each stakeholder, he says, at some point of time is either a catalyst of justice or directly affected by the outcome of the system. So one needs to understand and emphasize the symbiotic relationship existing between the stakeholders. As you all know, the guiding concern of all criminal laws all over the world is to try the offender and resultantly the redemption of the victim in any way. But this harsh reality was observed by the makers of the laws, and they found that victims, because of their vulnerability, they have been subjected to injustice. The accused is directly affected by the effectiveness and quality of the system. He has his own rights and entitlements, like presumption of innocence, a right to speedy investigation, speedy trial, so on and so forth. The importance of society as a stakeholder can be understood in the context of the government, the state taking up the cause of the complainants. After all, a crime is against the society at large, a qualified investigator, he would help the victim to get justice. He also theoretically is a bulwark against the oppression of citizens. So on his shoulders lie the maintenance of law and order, investigation and other duties. Courts, we must say, the courts have been seen as guardians of all stakeholders. A fair decision by him would require proper evidence collection, which is done by the investigator. He has to be professional in his approach, otherwise the whole system would crumble. Public prosecutors are absolutely indispensable. They help the court in coming to the right conclusion, in unraveling the solutions. Public prosecutors are not always expected to conform to the fancies and wishes of the state. His action comes, his responsibility comes post-investigation. So are the lawyers. They can either appear before, they have a right of audience, and they represent the victims, they represent the accused, and the third parties also if their interests are affected in any manner. He wears different caps. At times he wears the cap of amicus. His tenacity and skills are very important, and that actually takes the court to deeper levels. Now I am saying all this because these new laws, they have impacted all these stakeholders. That we must understand, and we must see it in this perspective. Now jails are viewed as symbols of justice, and it's a correctional facility. Well, the makers of these laws, they were wondering whether they still are correctional facilities, and therefore the jail reforms, the reforms in keeping a prisoner, in treating a prisoner, all these things are really important. And the fourth pillar of democracy, the press, I think many of the pressmen would be here. You see, media plays a pivotal role in affecting and shaping the opinion of the society, and thereby the perspective of the society. They can polarize and mobilize, as you have seen in the past, especially with respect to the court cases. Now, if this remains unchecked, which has been made an offense in the present dispensation, present penal code, it can impact the investigation, and I shudder to think they can even impact the adjudicating process, because there is always a tendency to fit in the narrative of the public perception shaped by the media, and therefore the injustice might occur. Likewise, the stakeholders their functions and their responsibilities have been taken care of in these new changes. The investigation, the arrest procedures, if they are not followed properly, it attracts a lot of flack. Herein comes the bail laws, the rights of the accused persons. The bail laws, the laws relating to search and seizure, attachment, confiscation, forensics, medical investigation, trial procedures, consideration and consequences of sentencing. These are some of the core issues which have really been addressed by these three laws. As you would hear from the speakers, there are changes everywhere. The penal code now has become victim-centric, justice-centric. New punishments have been added. For the first time, community service has been introduced. The key focus is on reformation, women's safety, rights of under trials, special reference to mob lynching, corruption in public life, procedure about proclaimed offenders, so on and so forth. One of the most discernible things which have come in the process are the trial in absentia against the proclaimed offenders and use of technology to connect and protect, envisioning unparalleled modernity. Digitization from EFIR to police investigations to court proceedings, they have been provided for. Forensic procedures have been made mandatory in cases with punishment of 7 years or more. And most important of all, mandatory audio-video recording to cover the entire process of search and seizure, which might be prescribed before the court as evidence. the accountability of the police has increased. For the first time, the concept of preliminary inquiry has been introduced, which was not there before. It was in departmental proceedings, domestic proceedings, but in a police investigation, preliminary inquiry would help the accused and the victim to understand whether their allegations are correct, whether a person needs be arrested. There is absolutely new approach to appreciating evidence. But my hobby horse, so to say, is to talk about sedition. The most talked about changes is in the sedition laws of the present penal code. We have heard so many controversial things in perspective. The new provision may not be labeled as sedition, but Section 150 of the BNS covers a wide range of acts, and the critics say it suffers from ambiguity and vagueness, creating implications for its constitutionality. I do not agree. See, the changes were gaining ground, the perceptions were changing with respect to the concept of sedition. Mere showing disaffection to the government or contempt or hatred towards the government, as in the present law it is not held to be sedition, so was the interpretation of the Supreme Court in the earlier law when it was named sedition. The section was called sedition, but then every time each case was examined threadbare by the Supreme Court and law was enunciated, and I think it gained ground. It had the acceptance of the civil society and the legal experts by around 1960s. See, one Kedar Nath Singh, a politician from Begusarai, he had criticized the ruling Congress party of that time for its capitalist policies and had advocated for forward Communist party. He was convicted for sedition. His appeal was dismissed by the High Court. Before the Supreme Court, he had argued that sedition law violated his fundamental right of freedom of expression. The case was heard by a constitution bench in Supreme Court. B.P. Sinha, then Chief Justice, presided the bench. They found the provision under Section 124A of the earlier code to be a restriction on the right of freedom of expression, but it was a reasonable restriction for maintaining public order. Criticism of a party or person is different from government established by law. Only if it has a tendency to raise tumult, thereby disturbing public peace, would the offense be said to have been committed. Similarly, there was a movement of Khalistan. One Balbant Singh was accused of raising slogans in favor of Khalistan. He was prosecuted. The Supreme Court said no. These slogan shouting casually would not raise such tumult as to fit in the definition of sedition. And it was a casual, isolated romanticizing of a person who thought that Khalistan could be made. The Supreme Court only recently quashed the FIR against the accused on the ground that dissent over a policy action of the government is no sedition. You have heard somebody from Karnataka or down south, I don't know, there was a WhatsApp group where they hailed Pakistan and also spoke something which was, to the perception of the people, a sedition. It was against the government. When the matter traveled to Supreme Court, the Supreme Court, in a very cogent manner, said that WhatsApp is a limited group. It's a club which does not have easy access to persons who are not the members. Therefore, anything said or expressed there would not fall in the category of sedition. But this was a very broad interpretation, and this is in tune with what the government wants now, what the lawmakers want now, and what was interpreted earlier. These, therefore, should not give you any, collywobbles that it is going to be misused. Section 150, the new 50, because it says if it causes disaffection with the government. Now you have to accept it with the present day interpretation of what sedition is. And the professionalism of the police will ensure that. what could have been the intention of the union government to abolish the laws and roll out new laws? This was, in my estimation, to provide convenience to people for breaking the shackles of colonialism. Now, in this context, a word about the common law is necessary. Now, why there is a great, perception, there is a great statement, great, effort to show that we are breaking from the past, from the colonial past. But why? Why? History is not always bad for you to understand, for you to process yourself. The English always took their law with them wherever they carried their flag. When the Dominions severed their political ties with Great Britain, they retained the common law. An interesting anecdote in the legal history is that no country which had not at some point of time or the other been a part of British Empire had ever voluntarily accepted the common law. After the First World War, Japan had adopted a new system of continental law in spite of its close commercial links with England and the US. Turkey took its criminal law from the Italian code and civil law from the Swiss and German codes. The stark fact is that whenever there was a choice between one common law and the Roman law, which is the basis of modern continental codes, the decision has always been in favor of Roman law. The main reason was that the Roman law is in the form of a code and is far more convenient to understand than the common law. In comparison, the common law is a strange amalgam of case law and statute law. Even the most inveterate, dyed-in-the-wool Britishers have started doubting about the efficacy of common law system, and therefore, this was decided that we must have our own law with changes based on the experience. See, a jurist has said that life of law is not logic or draftsmanship. That's important, but it does not constitute the backbone of a law. The experience has shown that it was almost necessary and emergent to bring about these reforms. And these reforms, you see, they have come about not standalone reforms, but after it was deliberated on the basis of experience that we had for 100 years. So these set of laws, you must accept it as an experience of 150 years, because we had been following a procedure of law right from early times. It deserves accolades. It deserves to be decoded layer by layer and appreciated too by all of you and all of us. Thank you.
Thank you so much, sir. Really, we are truly grateful to you for sharing your valuable words. Honorable Mr. Justice Ashutosh Kumar, sir, Patna High Court. Before I invite our chief guest for his address, a short introduction about Honorable the Chief Justice, Mr. K. Vinod Chandran. Born on 25th April 1963, obtained law degree from Kerala Law Academy Law College, Tiruvananthapuram, started practice in year 1991, served as special government pleader of the government of Kerala from 2007 to 2011, sworn in as additional judge of High Court of Kerala on 8th November 2011, appointed as permanent judge of the High Court of Kerala with effect from 24th June 2013. Okay, may I have the honor to invite our Honorable Chief Justice of Patna High Court, Mr. Justice K. Vinod Chandran. Thank you, sir.
Thank you. Mr. Justice Ashutosh Kumar, JD1, Judge of the Patna High Court. Mr. Justice Jarmalia Bakshi, Judge of the Calcutta High Court. My affectionate brothers on the bench who have taken time off from their busy schedule on weekends. Sri Prasant Kumar Shai, Learned Advocate General. Sri B.G. Harindranath, Senior Advocate, former District and Sessions Judge, Law Secretary, and also a member of the faculty of National Judicial Academy. Sri Chaitanya Prasad, Development Commissioner, Bihar. Sri Rajvinder Singh Bhatti, Director General of Police, Bihar. Sri Arvind Kumar Chaudhary, Principal Secretary, Home Department, Bihar. Sri Neeraj Tiwari, Assistant Professor, NLU, Delhi. also a former faculty of National Judicial Academy, the participants, judges, investigators and prosecutors, members of the print and electronic media. Let me begin by commending the state and its officers and of course the Learned Advocate General for organizing this program. This is the second of such programs organized in this very venue, and as spoken of by the earlier speakers, it was done far before the implementation of the laws. This shows the commitment of the government of Bihar to empower the stakeholders and enrich the criminal judicial system in the state. We are on the cusp of a major change. Already interpretations are coming from different states. It will bring forth new challenges, and we can also hope for enduring solutions. As my brother said, it is the adaptation and acclimatization that is required. I always felt that, in a lighter vein, animals adapt faster than human beings. These programs are intended at helping us to adapt and acclimatize to the new regime. I wouldn't speak on the nuances of the laws. You have eminent panelists who will speak on it. But as the Advocate General said, I agree that there is an emphasis on forensics. But I beg to differ on there being no room for manipulation. I'll come to that later. I read a recent report in the Times of India on 15/7/2024, which is titled India's Crime Scene Incapacity. When we have an emphasis on forensics, which has been highlighted in the report, they also underline the lack of infrastructure. Across the country, the lack of skilled staff comes to around 68%. And they have also graded the different states. Karnataka comes first. They have appointed 230 scientists and 206 scene of crime officers and state-of-the-art equipment even before the implementation of these laws. These scene of crime officers visit the crime scene along with the police officers. The Kerala, I am happy to see, is second, but there is a wide gap from Karnataka. Bihar also has to augment its infrastructure, and there is gross shortage of skilled forensic staff. I take the suggestion made by the Learned Advocate General that the Chanakya National Law University, I'll talk with the Vice Chancellor and ensure that there is a course on forensics. The lack of staff is not necessarily because of lack of appointment. It would also be due to lack of availability. This has to be looked into. But on my difference of opinion, it is famously said that witnesses may lie, but circumstance will not. There is a common perception that forensics with the backing of science, again, would not lie. But we should understand that circumstances are, after all, a human perception. And forensics, though backed by science, science is, of course, a human endeavor. The deceit of human beings often overcome their brilliance. That is what we see on the field. When we talk about forensics and circumstances, I would take some of your time to speak about two cases, one abroad and one inside the country. A widely publicized trial in Australia in the year 1982 was with respect to the murder of an infant child by her own mother. You can get it in the Google. If you search for Lindy Chamberlain, you will get it. Lindy Chamberlain
was the wife of a pastor and the mother of 3 children. The family was camping out and the infant child was sleeping inside the tent. Hearing a cry, the mother ran to the tent and saw the child being taken away by a dingo. Dingo is a wild dog found in Australia. Her version was disbelieved by the police. The first inquest found her version to be probable, but the second inquest indicted her. She was tried and convicted for life sentence. Her husband was also convicted as an accomplice. In the trial, the evidence was purely circumstantial. The child was never recovered. The body of the child was never recovered. What mattered in evidence was the recovery of a dress of the child, which the police asserted that was manipulated by the accused. However, the accused, their version was that the child was wearing a jacket while the dingo took it away. One other evidence again was on forensics. Traces of blood was found on the car. These were the 2 circumstances, including the forensic test, which, of course, the forensics were not developed in those times. She was handed a life sentence, and after about 4 years, there was a chance recovery of the jacket, which the accused said the child was wearing, and the police maintained that it never existed. This jacket was discovered from near the lair of a dingo. A commission was appointed. The commission gave her the benefit of doubt. She was released on remission. Again, after 4 years, the Supreme Court acquitted her. Again, on benefit of doubt. The couple did not rest content. They pressed for a clean acquittal. It was after almost four or five inquests after that, in the year 2012. Remember, the crime happened in 82, and in the year 2012, she was given a clean acquittal. The finding in that inquest was that the dress recovered by the police, before the recovery, there was some human interference. And the traces of blood found on the car was found to be a sound deadening compound used in the paintwork of the car. So much for forensics and circumstances. One other case that this is not publicized, probably just Mr. Harindranath would know about it. Justice U.L. Bhatt, a celebrated judge of a court, who joined first the higher judiciary, always spoke about a trial he conducted. A missing man complaint was registered, and later the police accused 5 persons of murdering him and burning the body to ashes. The body was never recovered. During trial, Justice Bhatt told us that he was convinced that the evidence was convincing. But later, while analyzing the evidence and writing the judgment, that is when the judges collect their thoughts and dictate their findings, he acquitted them. 4 years after that, the missing man walked back into his village. Justice Bhatt always spoke about the trauma and anguish he experienced when he read it in the newspapers. Because he said he thought of the consequences if he had convicted him, if his finding had been otherwise. This consequence is the caution we as investigators, prosecutors and judges have to bear in mind always. Collating evidence, calibrating it, presenting it before a court of law, and entering a find of guilt or otherwise is a daunting task. Investigators, prosecutors and judges are often eulogized for the convictions. and likewise they are vilified for acquittals. Public outrage on crimes in society is quite common and normal. But then how do we as investigators, judges and prosecutors insulate ourselves from the public outrage is the question we have to consider. Just as public outrage, we cannot be investigating or prosecuting or deciding a case based on the morals we live by or the philosophies of life we believe in. One has to always think about the consequences of a wrong conviction on the accused and his family, and a mistaken acquittal on the society. While opposite would be reference to the motto of the Office of the Attorney General in the United States. It is engraved into the woodwork of the Office of the Attorney General that the United States wins its case when justice is done to one of its citizens in courts. So it is not, we are not here as participants of the justice delivery system, criminal justice delivery system, either to convict or acquit. We do not have an inquisitorial system, but it has always been said that even in the inquisitorial system, our endeavor is to find out the truth. While finding out the truth, that is why there is a caution expressed that truth, not by our moral values, but and not as an individual perception of what truth is. Truth as a reasonable man would find based on evidence without an iota of reasonable doubt. This is what drives our criminal justice delivery system. It's been a pleasant few minutes speaking to you all. Once again, I thank the organizers for the wonderful program organized by them. The participants are in for an enlightening experience in the next 2 days. And last but not the least, I thank the eminent panelists who have taken time from their busy schedule to come here to Patna and be with us and share their experiences. Thank you.
Thank you so much, sir. From bottom of our heart, I would like to thank our Chief Guest, Honorable Chief Justice of Patna High Court. Thank you so much, sir. And now I would like to request all the dignitaries and participants to proceed outside the auditorium for the high tea. We will have 15 minutes break, and after 15 minutes we will start our first session. Okay, so you all are requested to be in time after 15 minutes. Thank you so much. With this we end our inaugural session, and after 15 minutes we will start our next session. Thank you so much. All the dignitaries, thank you so much. Bihar. I would like to request all of you, please be seated so that we can start our session. After the inaugural session, our first session is on overview of changes in new criminal major acts. ब्रेक के बाद आप सभी का पुनः मैं स्वागत करती हूं। गृह विभाग, बिहार सरकार और जिला प्रशासन पटना द्वारा आयोजित इस 2 दिवसीय कार्यशाला के उद्घाटन समारोह के बाद टी ब्रेक के तुरंत बाद हम यहां हाजिर हैं अपने पहले सत्र को लेकर, और इस सत्र का विषय आप सभी परिचित हैं, नए आपराधिक जो हमारे मेजर एक्ट्स हैं, न्यू क्रिमिनल मेजर एक्ट्स, नए आपराधिक कानून विषय, उसी पर केंद्रित है हमारा ये पहला सेशन। और इस सेशन में हमारे कई ऑनरेबल स्पीकर्स हैं, गेस्ट स्पीकर्स के रूप में हमारे बीच हैं। मैं उनके बारे में बता दूं कि फर्स्ट सेशन है और फर्स्ट सेशन का हमारा टॉपिक है ओवरव्यू ऑफ चेंजेस इन न्यू क्रिमिनल मेजर एक्ट्स। और गेस्ट स्पीकर के रूप में सबसे पहले हमारे बीच आएंगे ऑनरेबल जस्टिस जयमाल्या बागची, कोलकाता हाई कोर्ट। उसके बाद हमारा जो सेकंड सेशन होगा उसमें हमारे जो ऑनरेबल गेस्ट स्पीकर हैं वो हैं श्री B.G. हरिंद्रनाथ, सीनियर एडवोकेट। और इनके इस सेशन के बाद हम लंच ब्रेक करेंगे और लंच ब्रेक के बाद फिर हमारा थर्ड और फोर्थ सेशन होगा। और थर्ड सेशन के हमारे ऑनरेबल गेस्ट स्पीकर हैं मिस्टर नीरज तिवारी, असिस्टेंट प्रोफेसर NLU दिल्ली, नेशनल लॉ यूनिवर्सिटी दिल्ली। और आज का जो आखिरी सेशन होगा, जो हमारा फोर्थ सेशन होगा, उसके ऑनरेबल गेस्ट स्पीकर हैं श्री भृगु श्रीनिवासन, डायरेक्टर बिहार पुलिस एकेडमी राजगीर। इनॉग्रल सेशन के बाद 4 सेशन लेकर हम बारी बारी से आएंगे और हर एक सेशन के हमारे एक ऑनरेबल स्पीकर है। तो हमारे ऑनरेबल द चीफ जस्टिस ऑफ बिहार पटना हाई कोर्ट यहाँ हाजिर है। उनके अनुमति से मैं इस सेशन की शुरुआत करूँ सर। ओके, आप सभी व्यवस्थित हो जाए, आप सभी बैठ जाएं। हम स्टार्ट करने जा रहे हैं अपना ये सेशन। हमारे ऑनरेबल गेस्ट स्पीकर यहाँ आ चुके हैं डायस पर। इससे पहले मैं उन्हें इनवाइट करूं अपने एड्रेस के लिए। आई वुड लाइक टू इंट्रोड्यूस अ शॉर्ट इंट्रोडक्शन अबाउट ऑनरेबल जस्टिस जयमाल्या बागची, Kolkata High Court. Did his schooling from Calcutta Boys School, passed LLB 5 years course from Calcutta University in 1991. Stood first in all the LLB examinations, enrolled as an advocate on 28th November 1991. Commenced his practice at the High Court at Calcutta from 1991. Appeared in a number of important cases relating to criminal and constitutional law, including death sentences and clemency cases before the High Court at Calcutta, other high courts and the Supreme Court of India. Argued successfully before a special bench of Calcutta High Court against the ban imposed by the state of West Bengal on the book Dvikhondito, written by Bangladeshi author Taslima Nasreen. Mr. Justice Jaymalia Bagchi was impaneled advocate for Union of India, State of West Bengal and other corporations, including Kolkata Municipal Corporation, Kolkata Port Trust and Calcutta Electric Supply Corporation. Was part-time lecturer of University of Calcutta Law Department and Jogesh Chandra Chaudhary College of Law. Was invited as guest lecturer to the West Bengal National University of Judicial Science, Kolkata. was guest speaker in UGC-sponsored refresher courses for lecturers on human rights in India at Jadavpur University and Charuchandra College, Kolkata. Has written various articles on legal topics which were published in reputed journals, appointed as a permanent judge in the High Court at Calcutta on June 2011. May I have the honor to invite our guest speaker, Honorable Justice Jaymala Bagchi, Kolkata High Court. For the first session, topic is Overview of Changes in New Criminal Major Acts. Welcome, sir.
The Honorable, the Chief Justice of Patna High Court, Justice Vinod Chandran, my brother, Justice Ashutosh Kumar, my other brother justices of Patna High Court, the learned Advocate General, Mr. Shahi, the Director General of Police, Mr. Bhatti, the Chief Secretary in charge of Bihar, the Principal Secretary of Home Department, Mr. Harindranath, Senior Advocate. On the dais, Mr. Neeraj Tiwari, the Assistant Professor at NLU Delhi and perhaps one of the think tanks of the new laws. My brothers and sisters in the district judiciary, senior police officers, civil servants, and friends. A very good afternoon to all of you. At the outset, I must express my gratitude to the learned Advocate General of the state of Bihar to invite me to this August exchange on the overview of new criminal laws. Whenever I go to these sort of sessions, the first question which is asked or debated, were these laws necessary? Or was it necessary to change the tripod on which the criminal justice system rested for more than a good 1.5 centuries? The answer really, friends, lies in a multiple factors and issues, and I propose to go into each one of them. First, primarily, is a historical one. The country had witnessed presently one of the most significant changes in the administration of criminal law, which transited from the Indian Penal Code, Code of Criminal Procedure and Indian Evidence Act to the Bharatiya Nyaya Samhita, Bharatiya Nagarik Surakha Samhita and Bharatiya Saksha Adhiniyam. Since the 19th century, the criminal justice in India was administered by laws made by its colonial masters. While these laws were in force over 1.5 centuries, their origins, in fact, were rooted in Western jurisprudence, particularly in the Napoleonic Code and the Louisiana Code enacted in the 19th century. And interestingly, apart from the Louisiana Code, India was the first colony of the British Empire where the Britishers tested the idea of Roman law or statute law in governing criminal justice system instead of common law. So India became a fertile ground for testing how positive law made by the king or the state would govern instead of judges defining crimes and prescribing punishments. Macaulay, as you all know, was the architect of these three laws. And interestingly, Macaulay is said to have commented the necessity of the positive law to govern India in these words. He says, and I quote, "I believe that no country ever stood so much in need of a code of laws, unlike the British Isles, which was governed by common law at that time, as India. And I believe also that there never was a country in which the want might be so easily supplied. Our principle is simply this, and that is the Grundnorm, or the basic jurisprudence of the criminal laws made by the colonial masters. That is, uniformity when you can have it, diversity when you must have it, but in all cases, certainty." So certainty principle was the principle which prompted the British masters to bring in the idea of continental codes to govern the colonies, particularly a diverse colony as India, where there were multitudes of jurisprudence, legal principles, and the criminal justice system rooted in Hindu law and Islamic jurisprudence. But unfortunately, Macaulay, unlike the other Indologists like William Jones, and I'm proud to say a former judge of the Supreme Court of Bengal, and the person who was the creator of the Asiatic Society, he was no Indologist. He had no love for ancient Indian philosophy or jurisprudence. He said, and his disdain is evident from his remark, that a single shelf of a good European library was worth the whole native literature of India and Arabia. I would humbly dissent and say Lord Macaulay's idea was extremely superficial and perhaps was born out of contempt which was generated in order to subdue the Indian mind and the Indian spirit and its pride in the centuries of jurisprudence which forms the very ethos of the nation. So this is the historical perspective which necessitates a revisit of these three colonial laws which govern the country till today. And before I proceed further, I would give a few vignettes of the ancient Hindu jurisprudence on the criminal justice system and compare them with its contemporaneity with the evolution of similar principles in the Anglo-Saxon jurisprudence. And I quote, on the issue of proportionality of punishment. And mind you, I quote from Kautilya, which relates 2,300 years ago, and definitely 2,000 years when the Indian Penal Code was being made. And when the Indian Penal Code was being formulated, the idea in English common law was of sentencing and penology based on the utilitarian theories of John Stuart Mill and John Bentham. And the Benthamite idea of deterrence was that put in the maximum sentence even for the smallest and the minutest of punishments, because the utilitarians did not believe that punishment was individual-centric. Their belief was punishment is society-centric, and we have to put the fear of God in others in society so that they do not commit similar act which the offender has. And so even a pickpocket in 18th century England would be put to the gallows. But in 2300 BC, 230 or 300 BC, that is 300 years ago, Kautilya speaks of proportionality of punishment in these words. It is the power of punishment alone, when exercised impartially in proportion to the guilt, irrespective of whether the person punished is the king's son or an enemy, that protects this world and the next. Friends, I have never seen a better enunciation of the idea of penology in any contemporary jurisprudence, even in the 20th or 21st century. These words take into consideration proportionality, take into consideration impartiality, and take into consideration the ultimate champion of rule of law. We talk of Lord Coke when we speak of rule of law being higher than the king. We know when King Charles spoke of him being above the law, Lord Chancellor Coke said, howsoever high you may be, the law is above you. This again was in the 18th century. Kautilya's Shishya or disciple Samandika in Niti Sara speaks of the utility of criminal justice system as protecting individuals not only from corrupt officials but the king himself. And in doing that, lays being higher than the king. And I quote, subjects require protection against weak officers, thieves, enemies of the king, royal favorites, that is, the acolytes of the king, namely the queen, the princess, etc., and more than all, against the greed of the king himself. So again, 200 BC, 2,300 years ago, you get jurisprudence in our own land which speaks of the rule of law going above the king. This I have. And finally, let's talk a very interesting idea of gender justice. Again, coming back to Kautilya. In 1990s, if I am not wrong, the Supreme Court had to deliver a verdict saying that even a prostitute has a right to refuse sexual advance. The dignity is the core of consent, and a sex worker should not be subjected to unwilling sexual intercourse. And let me compare with what was stated about rape in Indian jurisprudence 300 BC. Even a prostitute, and I quote from Kautilya again, even a prostitute cannot be enjoyed against her will. Each member of a gang raping a prostitute shall be punished. So the idea of dignity as one of the ethos of consent is rooted in Indian jurisprudence much earlier than what we find in the 20th century. Equality laws and jurisprudence of gender justice. Manu has spoken of assault, theft, robbery, false evidence, slander, criminal breach of justice, cheating, adultery, and rape. Proportionality of punishment has been attributed not only to the crime, but also with regard to the status of the individual and the individual's position in society. That is, namely, a higher and a more responsible person is required to be punished with a graver degree of sentence. The Indian scholars have repeatedly talked about duty, justice, and rule of law above the king and temporal powers much before Dicey and Coke championed these concepts in Western jurisprudence. Unshackling of the ideas of ancient Indian jurisprudence was one of the historical impetus which prompted the revisit of the colonial laws governing the criminal justice system. Next comes the more contemporary requirements of change. It has been commented by the Honorable the Chief Justice and the other dignitaries in the opening session that the changing profile of crime and the manner in which crime is committed today is completely different from what was in the 19th or the 20th century. Today, India sees, along with the world at large, globalization, technological advancement, and particularly information revolution through the internet. It causes transformative changes and creates opportunities of crime at diabolical levels and gargantuan proportions. It generates organized crimes where crime is not an individual activity but an enterprise in itself. It requires the redefinition of offenses and the application of criminal law, bearing in mind these substantial changes in society and the profile of crime itself. Law, like the proverbial tortoise, must keep up with these fast evolving societal demands. The enactment of the new penal laws is the need of the hour to meet these societal aspirations. As Lord Tennyson said, the old order changeth, yielding place to the new, lest a good custom should corrupt the world. Before going into the laws in detail, I would comment about the basic tenets of changes. In Bharatiya Nyaya Sanghita, the term Nyaya replaces penal. The very thrust in the definition is therefore Nyaya, that is justice, and not penal, that is punishment. So the idea of a justice-oriented administration of criminal justice system is encapsulated in the title itself. BNS introduces progressive changes, including separate chapter for women and children, for offenses against women and children, new crimes like organized crimes, petty organized crimes, snatching and mob lynching. It removes offenses which create gender bias like adultery and also consensual same-sex intercourses. It addresses the issue of terrorism as a general law and makes it applicable alongside the special law that is UAPA. It has incorporated, I'll come into that later. It has also incorporated certain gender non-specific victim paradigm and also cases where offenders can be prosecuted irrespective of their gender, aligning it with modern gender equality principles. Bharatiya Nagarik Suraksha Sanghita emphasizes on, in fact, three things. Firstly, timely justice. Justice delayed is justice denied. But in our experiences in the administration of criminal justice is that we ultimately are victims of enormous and at times avoidable delays. And that is sought to be addressed by creating timelines in the BNSS in every aspect of the criminal justice system, starting from investigation till the delivery of judgment in the trial court, as well as disposal of appeals and clemency petitions. Second, with regard to the BNSS, the stress is use of technology. Everywhere, from the registration of first information report, service of summons, investigation, access to courts, examination of witnesses. Technology is the handmaiden of justice today. And to do so, we are trying to evolve our investigating agencies and the law courts into a tech-savvy institution where a courtroom is a justice delivery mechanism without a room itself. You can access the courtroom from anywhere and have justice rendered to you. Finally, the third thrust of the NSS is forensic investigation. We know witnesses can lie, but circumstances don't. Many of the circumstances are rooted in forensic evidence, like the proverbial fingerprint at the place of crime, the hair on the body or the wearing apparel of the accused, the DNA matching of the accused with the bodily fluids found at the place of crime, etc. Paul Kirk, an expert in forensic sciences, defined them as silent witnesses, these forensic evidences. And these silent witnesses are most essential to unravel and punish an offender when eyewitnesses turn untruthful and do not support the case. They ensure the delivery of justice, notwithstanding the hesitance of individuals to support the cause. Finally, Bharatiya Saksha Adhiniyam. Bharatiya Saksha Adhiniyam modernizes the Evidence Act of 1872 by enlarging the scope and definition of digital evidence. Today, friends, we are in a domain where documents are passed. We would either have oral evidence, and that too through electronic means, or we would have digital records. How many of you have received a letter from your friends? How many of you have written a letter in the last, let's say, 5 years? Most of us exchange our feelings through messages on networking sites or other means. Exchanges are therefore all on digital platforms. The courts of today would be required to look into electronic records in place of documents. And when we require to do that, the Evidence Act needs to be revisited, and that is exactly what Saksha Adhiniyam does. It redefines the primary evidence in electronic records by expanding it and emphasizes on proper custody and preservation of digital records. The scope of primary evidence now includes digital storage, whereas secondary evidence encompasses matters stored in semiconductor memory. Certification requires dual purpose. It is not only the certification of the person in charge with regard to admissibility, but also with regard to its integrity and reliability on the basis of an expert who can match the hash value and state that the material or the digital record produced in court is not a tampered one. These will go a long way to deliver a justice system which is most effective, uses technology, and reaches out to the needs of the people through the best practices available. Now I come to the salient features. As Justice Ashutosh Kumar pointed out, Bharatiya Nyaya Sanghita or BNS makes a paramount change in the reformative idea of punishment. Lesser offences are not subjected to where you do not, let's say, a lesser offence where you do not, or you are not in a position to award someone probation. You may, instead of awarding sentence, substantive sentence, go for community service. And what is community service? Community service is court-ordered work that benefits the community and which is not entitled to any remuneration. And this is where, friends, I had spoken of the three reasons for change. One reason I said was a historical reason. Second reason I said was a change of profile of crime. And the third was the change with regard to availability of technology. The fourth reason for changes, and this I would, as I go through the salient changes, indicate, are the judicial pronouncements which have become now a part of statute law. Many of the changes in BNS, BNSS and BSA are in fact flagged by the Supreme Court and suggestions made by the Supreme Court which have been incorporated in law. Community service, friends, was in fact proposed by the Supreme Court in Sanjeev Narula's case, that is the BMW hit and run case. And in BMW hit and run case, the Supreme Court used Article 142 to direct community service as a reformative measure of punishment along with payment of compensation instead of enhancing sentence. The next aspect which I would like to touch with regard to the change of BNS is its reach. Indian Penal Code is lex loci, or it is the law of the land. Or in other words, it governs crimes or it governs acts and omissions which are offences committed in India. Only if an Indian citizen commits a crime or commits an act which is a punishable offence in India, he can be prosecuted for that crime abroad. There is an amendment where an offence has been incorporated which extends the reach of the Indian Penal Code not only to Indian citizens but also to foreigners who abet commission of an offence in India under section 48 of BNS. It says a foreigner who abets an act which, if committed in India, would be a crime, will be punished. For that, he need not abet with an Indian. He can abet with another foreigner. In other words, let's say someone in Canada abets another Canadian to purchase explosives for the purpose of blowing off or causing explosion in India. Even if the explosion is not committed, the Canadian individual can be prosecuted in India under 48 of BNS. This is a significant extraterritorial change in the law. The other extraterritorial change makes it in sync with the Information Technology Act that any computer resource in any part of the world, if is used as commission of a crime, which consequences are in India, the Indian Penal Code would stand attracted. The most significant change with regard to offence against women and child is to give chronological precedence to the batch of offences and club them together as a separate category in the BNS. It was very interesting to hear the learned Advocate General taking the cue that the comment is that the new laws are old wine in new bottles. And the best criticism has always been about this classification of offence against women and child. But there are certain very significant changes in offences against woman and child. One would feel it would be very important to see when you see section 76, which is outraging modesty. When you see section 77 of BNS of voyeurism, in these cases, the offences were considered as gender specific. Earlier, it was only a man who could outrage modesty. It was only a man who could indulge in voyeurism. Today, the word is any person. Gender of the victim is no longer relevant when it relates to procuration of child in section 96 and importation of a child from foreign country in 141 of BNS. It has all been made gender non-specific. A new offence has been incorporated in section 95 of BNS, which speaks of hiring, employing or engaging a child to commit an offence. Finally, I will come to the most discussed section, that is section 69 of the BNS. It speaks of penalizing sexual intercourse by employing deceitful means, that is false promise of employment or promotion, inducement or marrying after suppressing identity, or by making promise to marry without intention to fulfill the same. I would be hesitant to make definitive comments as to the purpose of this new provision. It would be for us in the law courts to interpret them. However, I would like to make a few remarks as a student of law. What section 69 really does is make something which is latent patent. The definition of rape, 68 of BNS, remains the same as it is in 375 of the Indian Penal Code. Consent, defined under 90 of the Indian Penal Code, remains the same as 28 of BNS. Interpreting 375, read with section 90, number of courts, including the Supreme Court, have held that if there was dishonest promise which procured the consent of an individual for sexual intercourse, it was no consent. So it is latent in 63 read with 28, what is made patent in section 69 of BNS. This I say again to all my honorable colleagues that it's their call to interpret. I have just made a comment as a student of law as I see it in the perspective of the law as it exists. The other change again in the offences against woman and child, and I wrap up the offence against woman and child there, is incorporation of a Supreme Court directive. Independent thought redefined the age of consent from 16 to 18. Legal, again going back to the Macaulayan idea, judgment law creating crime creates confusion. There is uncertainty that that judgment may be changed again. So what the legislator has done is bring in independent thought which redefines the definition from 16 to 18 as a part of 63 explanation 2 and made 18 as the age of consent. These are significant changes in addition to the repeal of adultery, which is again doing away with what the Supreme Court had already declared unconstitutional in Joseph's time, and repealing Now, repealing section 377 of the Indian Penal Code, that is unnatural crime, unnatural offences in Navdev Singh Johar versus the Union of India. However, I have some reservation about a complete repeal of 377 of the Indian Penal Code. I would have appreciated complete repeal of section 377 of the Indian Penal Code if section 63 of BNS would have been made gender neutral, as in POCSO Act. If you don't make 63 gender neutral, then non-consensual sexual intercourse between a man and a man does not become an offense, or at least a special offense. It is left only to general offenses like hurt or grievous hurt. This is something which the academicians, lawmakers need to consider. Then I come to the next chapter in BNS, that is offenses against human body. Offenses against human body, the most important thing is again another species of crime which has come into being because of collective violence. As I said, crime today is not individual oriented. It is community based, it is group based, it is faction based. Mob lynching, therefore, was an essential requirement to be redefined and specified as, or rather I won't say redefined, but called out as a specific offense and not made a general offense of murder read with common intention. One may say that murder as defined under 103 with common intention under section 1, subsection 4, I think, or of the new law, would take care of it. But to say that we lose the importance of creating and defining a crime which has special connotations. And the words used in mob lynching is slightly different from words used in the common intention under section 34 of the Indian Penal Code and also under the BNS. In 34 it is any act in pursuance of common intention. In mob lynching it is acting in concert. It would require interpretation whether mob lynching has a wider penal umbrella or penal liability than common intention. This again, friends, was translating which the Supreme Court specified in Tehsing Poonwala, that make a specific crime for mob lynching. Causing death by negligence has been a debated area. Death by negligence has been categorized in 3 categories. Negligence by a registered medical practitioner has been put into a lesser offense or a lesser penal liability category, and negligence by driving has been put into a very high category where the offense would attract punishment up to 10 years. However, because of some opposition to redefining the offense in this category, the 3rd category has not been notified. Now, the impact of non-notification, therefore, is the driving offences would fall in the 1st category, that is causing death by negligence by any person other than a registered practitioner, that is subsection 1 of section 106. Because my friends in judiciary, district judiciary will be facing this problem. Rash and negligent driving cases will come. They are specifically defined in subsection 2 of section 106. That has not been notified. So please treat them as offences under subsection 1 of section 106 under the general category and not under the registered medical practitioner category. Attempt to suicide was declared as offense in 309 of the Indian Penal Code. In Aruna Shanbag, the Supreme Court dealt with the idea of passive euthanasia and held that it is unfair to punish a person who, because of unfortunate circumstances, has attempted to commit suicide. In light of this, the offense has been repealed. It is also in consonance with 115 of the Mental Health Act. However, a new offense has been added. That is 226 of the Bharatiya Nyaya Sanhita, which penalizes an attempt to suicide to compel or restrain official duty. That is, if suicide is attempted by individuals like self-immolation, like commission of suicide as a part of agitation, in order to force a democratically elected government from retracting from a policy decision, it would be an offense. Finally, the offense of organized crime has been incorporated in the offense against body. I would have loved organized crime and petty organized crime to be categorized as a separate chapter, because they have a different texture, connotation and profile. Organized crime and petty organized crime are repeated crimes committed by a core group of individuals. And these organized crime and petty organized crime were already offenses in various state legislations, like the Makoka in Maharashtra, Andhra Pradesh Organized Crime Act. I do not know about Bihar, but other states, Orissa had an Organized Crime Act. Today, the penal law, that's the national law, has organized crime as a part of the offenses. Offenses against state, the most significant change is doing away with sedition, but introducing 152 as a new crime where acts, representations, financing or otherwise which induces armed rebellion, insurrection, impacting unity, integrity and sovereignty of the country. That has been incorporated. Justice Ashutosh Kumar dwelt on this issue, and I would completely agree with Justice Kumar that what the law has done is bring in sync the provision of 124A of Indian Penal Code in its new avatar in 152 of BNS with the principles laid down in Kedarnath Singh and its subsequent provisions, subsequent judgments. In Kedarnath Singh, the Supreme Court said, and Supreme Court held that the earlier judgments, including the judgment convicting Bal Gangadhar Tilak, was wrong, because criticism against government decision, government policy, disaffection against the government cannot be the core basis of the idea of resurrection against sovereignty. So what was the proposition in Kedarnath has now been given expression in 152. You would profit also in seeing a very relevant judgment in Amish Devgan, where hate speech, and as to what hate speech is, has been defined by the Supreme Court by giving three tests: that it must be context-based, it must be intent-based, and it must have impact-based taste. Or in other words, there must be a clear and present danger, expression borrowed from American jurisprudence, that the act or the representation had a clear and present danger to harming the unity, integrity and the sovereignty of the country. In addition to that, Section 197 of BNS has been brought in, that no publication of false and misleading information jeopardizing sovereignty, unity and integrity. Offences against property undergoes some changes in the form of bringing in snatching, which is a sort of hybrid between theft and robbery. You know, robbery is theft in an aggravated form. Snatching is not where the ingredient of hurt or extortion is there, but it is committed in a fashion which is slightly graver than theft. Now I come to BNSS, that is Bharatiya Nagarik Suraksha Samhita. The most important things which I would like to flag are the issues of arrest. Arrest of elderly persons, infirm persons in lesser offences have been restricted. And it has been said that no arrest shall be committed without the prior permission of the Deputy Superintendent of Police. Every arrest is to be notified in the District Police Control Room. And an arrestee by a private person must be produced before a police officer within 6 hours. The law declared in Siddharth and Satyendra Antil that if an accused has cooperated with investigation and was not arrested during the investigation, he need not be arrested or a warrant prayed for, but may give a bond for his appearance before court. This has now become a part of the statute in 190 BNS. 187 subsection 2 of BNS, which is corresponding to 167 subsection 2, makes a very important change with regard to police custody. We all know police custody is for 15 days, but the Supreme Court decisions restricted it to the first 15 days. That has been modified, and the police is entitled to call for police custody in a staggered manner between the first 40 days or 60 days of detention, as the case may be. The other thing which clarifies is whether offences up to 10 years will be 60 days or 90 days. It clarifies that offences punishable with 10 years now will be for 90 days and not 60 days. Then I come to first information report. First information report makes two significant changes. One, again it lays down the use of technology of making e-FIRs. And the second is zero FIR, which was envisaged by the Supreme Court sometimes in 1999 in Satvinder Kaur, that if I am traveling in a train, I get up in Howrah station with my bag. I am traveling to Patna. Suddenly when I reach Asansol, I find my bag is missing. I go to the GRP in Patna when the train stops, and I go to GRP and say that I boarded in Kolkata, I had a bag and now my bag has been stolen. The problem was, most of the government railway police officer will say, we cannot register the FIR because it is not within my jurisdiction. Now the zero FIR is one where you do not test whether the offence is within your jurisdiction or not. You register the FIR, commence the investigation, and then transfer the FIR to the jurisdiction where the offence is committed. The issue of e-FIR brings in interesting anomalies. And this was flagged by the learned Advocate General, and I was very happy that he did it. That what happens to an EFIR where intimation is given online, but the FIR maker doesn't come and register the FIR within 3 days? It becomes an inchoate FIR. Second, I flag another issue. Let's say I am a police officer. I am informed that X has stolen an antique piece from the Patna museum and would be boarding a flight immediately and going abroad. This I receive as an EFIR. Can I or can I not proceed to work on this information as a suo motu action? Or am I compelled? Because it all depends on the nature of information I receive. If I receive an information today, there has been a bomb blast at Gandhi Market on an electronic communication, that may not be an FIR, but that does not stop the police from working on intelligence. The police's requirement to work is not restricted on registration of FIR. They can suo motu work on intelligence. So in my understanding, an EFIR, if not registered, may be treated as intelligence. You remember, all of us as lawyers and then judges, we have seen when search and seizure takes place, the words are working on secret information. A group of police officers went. So this can be used as intelligence and police can work on it, but definitely cannot be treated as the first information report. If the signature is not made, the intelligence may be used to commence a preliminary inquiry and even search and seizure, where the FIR will be a suo motu FIR by the police saying that an intelligence was received by an unsigned electronic communication, and upon working on it, this is the evidence collected on which I am registering the suo motu FIR. So this is, in my understanding, how you handle FIRs which create a reasonable suspicion of a grave crime which needs to be immediately addressed but has not been signed. The other right is a wonderful right of the victim to be made, victim to have the right of a copy of the FIR, and the provision under 173(4) with regard to corresponding 156 subsection 3 says it must, no order should be passed until and unless his report is taken from the police that they have registered an FIR or not. Now I come to the investigation aspect. The investigation powers have been hinged by incorporating the principles of preliminary inquiry envisaged in Lalitha Kumari with regard to lesser crimes. Time frame has also been given of 14 days and thereafter the FIR to be registered. The directions for 156(3) under 175 subsection 3 have to be done on an application on the basis of an affidavit, which again is a direction of the Supreme Court in Priyanka Srivastav. The most important change in my assessment are 105 and 176 subsection 3 of BNS. 105 mandates every search and seizure to be videographed. And this is nothing new, because it is an acknowledgement of the Supreme Court in Shafi Muhammad and Paramveer Singh Saini. My High Court also had some humble role to play in this, dealing with innumerable cases of false implication in narcotic offences. My High Court gave direction that every search and seizure, particularly those which are on prior information, must be videographed. And this today finds statutory recognition in section 105 of BNSS. 176 subsection 3 is another important change which has been put back by 5 years because of the lack of forensic facilities. That there must be a crime scene investigation, a forensic crime scene investigation of all crimes which are more than 7 years, And that is very important for collecting trace evidence and protecting the forensic evidence to prove a crime. Another important change with regard to investigation is the statement of witnesses before magistrate, which was under 164 and presently under 183 subsection 6A of the NSS, may be used as examination in chief in appropriate cases. And for that reason, they have to be videographed. The next aspect that I would like to touch, before I close on investigation, further investigation during trial must be with the permission of the trial court, because there was some confusion and judgments as to whether further investigation, which was earlier under 173(8) of Code of Criminal Procedure, required permission or not. Now it is specifically stated that there is no difficulty in continuing further investigation, but it must be with the permission of the trial court. Complaint to magistrate makes a ticklish change. The complaint to magistrate is in section 223 of BNSS says that no cognizance can be taken without opportunity of hearing to an accused. In various sessions that I have attended, this has created different interpretations. I have been asked by judges, district judges, that what do we do? Do we take cognizance? Or if we don't take cognizance, how do I issue notice? My suggestion is, we require to either amend the rules, criminal rules and orders from the High Court, to say that whenever a complaint will be filed, a copy of the complaint must be served upon the prospective accused and an affidavit of service be filed. And upon that affidavit of service being filed, cognizance shall be taken. So that creates the rule-making structures to take care of the proviso that opportunity of hearing is given, because opportunity of hearing means notice and thereafter hearing. So first you take care of notice by framing the rules, and then if upon notice the accused does not appear, you send a fresh notice, and thereafter you proceed to take cognizance and issue process. Another aspect of the matter which requires to be addressed when opportunity of hearing comes in is, what is the nature of hearing do you do when cognizance is to be taken? Do you look into the defense of the accused at that time? Do you look into documents which may be filed on behalf of the accused and hold a mini trial? Maybe not. The requirement of hearing at the stage of cognizance is a hearing in the category of demurrer. It must show whether the condition precedent for cognizance is taken. And when cognizance is taken, if you see the provision in 223, you will find it is on a petition of complaint. So if it is on a petition of complaint, you cannot supply additional document even if you have an opportunity of hearing. You can address the court only on the material which has been filed by the complainant and his deposition, or rather the petition filed by the complainant, because that's at the stage of cognizance, and say, sir, cognizance cannot be taken. The second aspect is cognizance against public servants. It must be upon notice to him of the public servant and his superior and their report. However, although the notice to public servant creates a sieve in institution of proceedings against public servants, and also sanction under 218 has been enlarged to include all public servants, the sanction provision has been streamlined by stating that it should be granted within 120 days, failing which it shall be deemed to be granted. I am not going through all requirements of the timelines, because each and every stage there is a timeline. The next thing that I would address is another very important aspect which has been incorporated in section 356 subsection 1, that is trial in absentia. In fact, the Supreme Court in Hussain versus Union of India quoted the Bangladesh Criminal Court and other laws to say that time has come where we do not allow indulgence to a proclaimed offender, but proceed to try the offender and convict him in absentia to avoid sentence whenever the offender is found. This, in my understanding, goes a very long way in addressing timely justice, at the same time ensuring that the rights of the offender are protected. There are some changes with regard to scientific expert, which is very important, that both the central government and the state government has been given power to notify private individuals as scientific expert, which you will find is very relevant when we examine the provisions in Bharatiya Saksha Adhiniyam. The provisions for bail on ground of delay, that is 436A, has been made more liberal and may be applied by first-time offender when 1/3 of the maximum sentence is undertaken, and superintendent of jail has a duty now to intimate the courts that the time served by the under trial justifies him to bail on the ground of delay. Witness protection is another very important thing, where the provisions of Mahendra Chawla has been incorporated in 398 BNSS as witness protection. Mercy petitions are to be disposed of within 30 days as a part of the timeline. Finally, I would indicate the changes in Bharatiya Saksha Adhiniyam. In Bharatiya Saksha Adhiniyam, the most important changes is in the digital evidence aspect. The definition of primary evidence of electronic record has been enhanced. It includes today digital record created or stored simultaneously, sequentially in multiple files. Each file is a primary evidence. So in other words, let us say I make a record on my mobile phone or electronic device, I delete it, but the record in the REM or in the hard drive would also be treated as a primary record. The multiple files created sequentially, all are primary records. Electronic records produced from proper custody and not disputed. This has been the biggest problem when the certification in earlier cases, there was no certification with regard to telephone records and all. So if it is produced from the service provider and not disputed, the certification is not necessary, it is primary evidence. Video recordings simultaneously stored, broadcast, transmitted to another device. Each of the stored recording is primary evidence. So if I make a video recording in my phone and it is stored in the cloud of the server, the cloud of the server, the evidence collected from the cloud of the service provider is evidence. If I simultaneously broadcast something which is seen and accessed at various places, each of the places where it is accessed is primary evidence. Electronic record automatically stored in multiple storage places in a computer source, as I said, server, cloud, and any other device which is connected in the computer resource. Each device is primary evidence. This reduces the requirement of certification and thereby produce, let's say, in an IP proceeding of copyright violation, if I access a website where the violator has made a deceptively similar copy of a copyright, because it is accessed simultaneously, you do not require certification of the data received or accessed. The other aspect which the change takes place is the definition of secondary evidence is also increased. 63 of BSA includes electronic records copied in semiconductor memory in addition to optical or magnetic media as provided by Indian Evidence Act. It enlarges the ambit of the provision by covering electronic records produced in communication device or otherwise stored, recorded or copied in electronic form like DVR, flash drive, CD, DVD, server, cloud, and not produced by a computer only, as was in the case of Indian Evidence Act. The scope of these devices and electronic records can be sourced as evidence has been enlarged. And finally, this certification is not only to be made by the person in charge for admissibility, but also by an expert who may certify the authenticity of the record. The manner of certification is given in the schedule, and the schedule shows a uniform manner of certification which is to be followed. Section 39 of BSA, read with Section 79 capital A of Information Technology Act, says not only the certified examiner of electronic records, but any specially skilled person in any other field, including electronic evidence, can act as an expert. So you would therefore not required only to get a certification from the person who is certified as an electronic expert from the government, but anyone who has experience in digital evidence and has worked in the field under Section 39 of BSF, if he can demonstrate his evidence, can be admitted as an expert who can give evidence. With these, I conclude my comments on the specific provisions of the three laws. I would conclude by saying that the laws have been enforced and have come into being. What we require is a ramping up of the technology through the ICGS, the CCTNS systems, so that all the verticals of the criminal justice system are seamlessly connected electronically and the data be exchanged inter-C. The second aspect which is important is the ramping up of forensic facility, and to do so we must in my estimation, immediately tap upon this vast resource of academic institutions which have enormous potential both by human resources and otherwise, and to notify them as government experts in the field. The third is our eagerness as the service providers of justice to live up to the timelines of the law, because experience is that the timelines are all in theory but not in practice. Thank you very much for your patience. Jai Hind.
Thank you so much, sir. We express our sincere thanks to Honorable Justice Joy Malia Bagchi, Kolkata High Court, for your exceptional information and views regarding today's subject, overview of changes in new criminal major acts. Thank you so much, sir. And now we start our second session, and in this session our guest speaker is Shri B.G. Harindranath, Senior Advocate. A short introduction. The High Court of Kerala has conferred B.G. Harindranath with the title of Senior Advocate. Harindranath was among 20 advocates granted the senior designation during a full meeting of the Chief Justice of Kerala High Court, A.J. Desai, and other judges. As an experienced advocate, Harindranath has appeared before the Supreme Court of India, the High Court of Kerala, appellate tribunals, and statutory authorities. Prior to his legal practice, he was also the Law Secretary to the Government of Kerala from 2015 to 2019, Additional Director at the Kerala Judicial Academy from 2012 to 2015, and Professor at the National Judicial Academy in Bhopal, Madhya Pradesh in 2009 to 2010. He also served as a district and session judge in Manjeri and as a family court judge in Thiruvananthapuram in 2009. He is presently working as a senior advocate in the High Court of Kerala. May I have the honor to invite our guest speaker, Shri B.G. Harindranath, Senior Advocate. Sir, please. From this side, you want? Okay.
Honorable Mr. Justice Vinod Chandran, Chief Justice of the Patna High Court, Justice Ashutosh Kumar, Judge of the Patna High Court, Justice Joymala Bagchi, Judge of the Calcutta High Court, Mr. Prashant Kumar Sahi, Learned Advocate General, Sri Chaitanya Prasad, Development Commissioner, Bihar, Sri R.S. Bhatti, DGP of Police, Bihar, Aravind Kumar Chaudhary, Principal Secretary, Home Department, Bihar, my dear friend Neeraj Chaudhary, learned judges of the Patna High Court, distinguished persons on the dais and off the dais. Now, so far as I am running the risk, first thing you would be wondering why I moved from that end to this end. In fact, there is a laptop over there. And therefore, I cannot keep my iPad over there. There is not enough space. That is why I moved to this end of the dais. Now, as far as my lecture is concerned, very eruditely, Justice Joymala Bagchi has taken this gathering to the entire provisions of BSA, BNSS, and Bharat BNS. So, therefore, there is little left to me to address on the subtle nuances of these laws. Nonetheless, I would try to point out certain aspects which obviously he has dealt with, but still it would be appropriate to look at this. In fact, always when new laws are being discussed in Parliament or are being drafted, I had been the Law Secretary of Kerala government with two governments. Usually when the government changes, they send the Law Secretary back to the judiciary. I remained with both political parties, the LDF and UDF, for a period of around 4 years. So I know about something about drafting of the legislation and also presentation of that in the legislature. So whenever these things go on, I view this with great consternation because especially what would happen to the position of law and how it will impact not just the lawyers and judges who deal with it daily, but the litigants who come before the court. So far as these three laws are concerned, this is inextricably mixed with the Article 20-21 jurisprudence, the heart of our constitution. And if there is some wayward movement either way, everything would look be in jeopardy. But I should say that our Article 21 and 20 though is completely intact so far as these laws are concerned. There is not much of a change. And so far as BNS, Bharatiya Sakshya Adhiniyam is concerned, there is no room for change because it all is about equipping a trier of a fact to come to the right conclusion, going through the right method, that is looking at the relevant evidence and issuing out the irrelevant evidence. And that is what ultimately the Evidence Act is about. You cannot have a better philosophy in the Evidence Act than what has been stated by Stephen. You will find this in the Federal Rules of Evidence in American courts. You will find this in other jurisdictions where common law jurisdictions in various countries. They have not, even England, they have not changed this in any way. If you look at the Singapore evidence law, because I sometimes have gone through the judgments, it is exact replica of some of our Supreme Court judgments on Section 27, 25 and other matters, because they have the same provision in the Singapore Evidence Act. Now, so far as our Evidence Act, what the framers have done is, so far as the provisions relating to confessions are concerned, instead of 1, 2, 3, 4 sections, they have combined it in one section and the other things in subsections. So that is in a way, because proviso, it is Section 27 is a proviso to 25, 26 and 24. But now what the framers have done is one section and there is no room for any confusion because it remains as it is. The only thing is, when a new thing has come, we have to internalize the new sections. That of course for lawyers and judges is a difficult task. And also not for lawyers and judges, because 420 IPC has now changed. In fact, the cheat is always called 420. Abhi koi dusra number lag jayega. It is not the same thing. That is the only basic thing about changes brought about these things. So that's in the lighter vein. Now, so far as the Bharatiya Sakshya Adhiniyam is concerned, Evidence Act, in fact, classified evidence into primary evidence and secondary evidence, two classifications. Now, so far as primary evidence is concerned, electronic record is now primary evidence, as Justice Bagchi had pointed out. What has happened is the Supreme Court decision reported in Arjun Pandit's case, they had overruled the decision in Parliament attack case, where secondary evidence was admissible in the ordinary way under Section 65. But the Supreme Court said that when there is a special provision for certification in the amended Evidence Act, you cannot fall back on the general law. And therefore, in Anwar's case, they had changed that. And later, in Arjun Pandit, they had explored the contours of the entire digital evidence. And so far as the new Evidence Act, that is, new evidence law is concerned, they have just distilled the entire ratio contained in this Arjun Pandit's case, as well as the latest decision, that is in 2023 SEC, recent decision. Now, I am not going into the decision and other things. Now, so far as Evidence Act is concerned, they have also classified, in fact, the electronic evidence, as I just mentioned, is mentioned as primary evidence. See, as formerly, when a document is produced in two counterparts, simultaneously. Both used to be primary evidence. Now, so far as electronic evidence is concerned, at the same time or simultaneously it is recorded by different devices. Now, a person sitting over there is recording what I am saying here. It may be recorded in some other device also. All this, when it is recorded in these devices and this device is brought into court by somebody who is handling the device, who has got primary knowledge of that, that is primary evidence. So this is one salutary change so far as primary evidence is concerned in the new Evidence Act. As I told you, BSA retains a position espoused in Arjun Pandit Kotkar's case. Now, the other thing which is brought about by the new Bharatiya Sakshi Adhiniyam is digital integrity. So, digital integrity is very important. How do you find out the digital integrity of a document produced in court? Now, there is something called a hash value. Unique hash value is actually a fingerprint of an electronically stored document. It corresponds, if I may say broadly, it corresponds to the content of the file. Now, every time a document is copied, the hash value changes. So, the original has a hash value, and if the hash value keeps on changing, you find out that it is not the original. It is a secondary evidence. Now, Supreme Court has dealt with this in Amazon seller's case, and now the BSA maintains this. Now, hash value, that is, so it now mandates the recording of hash value in electronic evidence when the expert testifies about the electronic evidence. Because then, so far as BSA is concerned, since the BSA has mandated recording of hash value, it is easy for the courts to find out whether it is tampered or whether it is original or secondary evidence or primary evidence or not. So this is the most important salutary provision in the BSA. Now, so far as BSA, in fact, retains most of the provisions in the Indian Evidence Act regarding confessions. Now, you will find there is whenever you are dealing with a new provision, the best method to be in the news is criticize that. Then say that trenchant criticism is the order of the day. Then people will report that. Now, I was watching the other day, Prime Minister, our Honorable Prime Minister Modi was saying, when this mic failed, he said in a lighter vein, कल अखबार में ये नहीं आएगा कि माइक फेल हो गया, अखबार में ये आएगा कि मोदी की बोलती बंद हो गई. That is how people look at the akhbar and news items. Now, whenever you criticize, whenever you see something bad about something which has come, people will listen to that. But if you critically analyze this, critically people have criticized that this is a violation of Article 21, violation of that, violation of Article 20. It is absolutely not true, because fundamentally the Bharatiya Nyaya Samhita as well as the Bharatiya Sakshi Adhiniyam, it retains the essence of Article 21 and 20, ex post facto law, which I am not going into in detail. Now, protection of civil liberties are concerned. The confession given to the police officer, even now it is not admissible. Now, if you take the case, we have a better protection against confession to the police, misuse of the police powers in our Evidence Act than the Western countries, where other common law countries. In other common law countries, you find that the Miranda ruling came somewhere in 1960s. In fact, USA, as you find, US courts were very conservative, and sometimes they protected all tendencies which are not proper for a just society. You all would remember now what triggered the American Civil War. US President Abraham Lincoln issued the Emancipation Proclamation, which gave rise to the civil war between the South and the North, Emancipation Proclamation banning slavery. Just before that, you will find a decision of the US Supreme Court, Dred Scott's case. Chief Justice Roger Taney in Dred Scott's case held that black is a property, and black, since he is a property, does not have any rights, because property rights are more sacrosanct than the black's human rights. That is what has been held in Dred Scott's case. But if you look at the original US Constitution if you look at the founding fathers, how they treated blacks, they were considered 2/5 of white. Because in the American Constitution, when the seats in the Senate Congress were fixed, because there were a lot of blacks in the southern states, they said 2/5 black is equal to 1 white. So that is how the American Constitution saw blacks. Now, why I am coming to this is, in Brown versus Board of Education, United States Supreme Court was hearing the case, and they were going to uphold racial segregation. So then what happened is, Chief Justice Fred Vinson died on the bench. President Eisenhower appointed Earl Warren as the Chief Justice. He was then Governor of California. He came, and though Supreme Court is going to uphold under Fred Vinson the black segregation laws, they overruled it. Desegregation was made the law by the Supreme Court. Later, you find in Miranda's case, Miranda warnings you must have seen in the movies, that you have to warn the accused. He should be provided police protection, and then that anything said by you will be used against you. This warning has to be issued. Unless this warning is issued, the confession made to an investigating officer is not admissible in evidence. But look at our evidence law. We are far ahead of them. Though it is before the Constitution, Stephen had framed this. No confession made to the police officer is admissible in evidence. In fact, your Chief Justice Vinod Chandran, while he was in Kerala, has written a judgment in criminal case. He is not just a tax lawyer. He quoted Stephen's book and said that police, those days, used to rub red chili powder in the poor devil's eyes, rather than go under the sweltering sun in search of evidence. So the mindset that Stephen had stated, that you can find that in the judgment. Even now, to a great extent, in our, whether it is Kerala or Bihar, the police mentality has to change. Of course, it has to change. I am not criticizing the police. Now it has changed a lot. Obviously, it has changed a lot. But then we have retained this section 25 and corresponding section to 161. Any statement given to the police can be used for no purpose except for contradiction as contained in 145. It is still retained. What better provision can be there to protect our fundamental rights? So we don't require Miranda's case. But there is one area. But if laws, there is one area which this confession law is concerned, requires, in fact, you would remember the decision in Selvi's case. Selvi's case pertaining to narco analysis. We have several investigating agencies, which nowadays you have the ED, you have the customs officers, you have the SFIO. So these are all not police officers. Any confession made to them is admissible in evidence under law, because they are not police officers, because section 25 does not apply to them. But then the judicial decisions say that in such a case, it is a duty, especially Selvi's case says that involuntary confessions, not voluntary confessions, involuntary confessions are given to non-police officers are inadmissible in evidence. It has to be voluntary. Now, this is one aspect which we have to explore further, because Selvi's case has clearly provided that. Now, I would now I just found one difference. 114 became 119, that is 114 relating to presumptions. Then 107 and 108 became 111, 110 and 111 in the new BSA. But then that was regarding the presumption, that is burden of proof, whether a person is dead or not. Now 111, Supreme Court in 2005-8, SEC 350, as well as the Privy Council in 1925 held that it is a proviso to section 105. Now the word proviso is not seen there. Nonetheless, even if it is not there, by virtue of these judicial decisions, it is still a proviso to, if a person is not seen for 30 years, he is presumed to be dead. But then the burden shifts to the other side. And if he is not heard by, if he is heard that 7 years by persons who are like immediate relatives, if they hear about them, then the presumption shifts and the burden of proof shifts. What presumption does essentially is to shift the burden of proof. Now, this is what I have to say about the evidence law. The key changes in BSA pertain to electronic evidence itself. And as I stated earlier, in fact, the quintessence of Arjun Pandit's case and other cases have been held and retained in the evidence law. It has been done in a proper way. Now, so far as Bharatiya Nyaya Samhita is concerned, now you find new offences in Bharatiya Samhita. Now, in fact, Justice Ashutosh Mukherjee had stated one sentence from Oliver Wendell Holmes' Common Law, that life of law has not been logic. Oliver Wendell Holmes says, the life of law has not been logic, it has been experience, the felt necessities of time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even prejudices which judges share with their fellow men have a good deal more to do than syllogism in determining the rules by which men should be governed. So the march of law is not determined by syllogism. It is a felt necessity of time. It is the intuitions of public policy. It may be avowed. It may be unconscious. Oliver Wendell Holmes says that this plays a great role in the march of law. Now, if you look at the Bharatiya Nyaya Samhita, you find that cheating in an exam, now you have this NEET, they have cheating in NEET exam. That is under 112, it is an offence now, specific offence. Now you find there was cheating in a cricket field, that people are selling out and then dropping a catch for money. So these are all matters. They were acquitted because there was no provision to convict them. Because if you drop a catch, you cannot convict the person. There is no provision in the Indian Penal Code or any code to making it an offence. Now, cheating in exam has been made a specific offence. Now, section 113 of the Bharatiya Nyaya Samhita. Now, it deals with terrorism. Terrorism is in the recent years, it's an offence. Terrorism was not prevalent at the time of when Macaulay drafted 1860 Indian Penal Code. But it is a fact of life for us. It happens everywhere in the country. People are terrorized by militants. So terrorism specifically has been made an offence under section 113. Now the definition is also, see, what is terrorism? Whoever does any act with intent to threaten or likely to threaten the unity, integrity, sovereignty, security or economic security of India is said to have committed terrorism. We all know it's fact of life. Now these things do happen in our country. These things not only happen in our country, it happens globally. So 113 has now provided a specific section for that. Now counterfeiting. Now look at counterfeiting. Counterfeiting is also a part of terrorism. If you counterfeit, during the Second World War, what Hitler did was, he used to counterfeit dollars and then throw it in London and other places, so that people will have a lot of counterfeit money and their economy would be disrupted. Now, using bombs, dynamite, other explosive substance, firearms, weapons, noxious gases or other chemicals, or by any substance, radioactive, nuclear or of hazardous nature, cause death or injury to a person, loss, damage, disruption to supplies or services, damage to the monetary stability of India by production of smuggling or circulation of counterfeit Indian paper currency, coin or other materials. Now, because we are marching into a digital economy, most of these counterfeit, we have been able to save our economy from that, because India is now the largest digital economy. I remember seeing messages in WhatsApp and other things. Lampooning the introduction of digital economy, because Anpad Bharatiya, people who are not educated, he cannot write. How will he use a mobile phone or a digital device? Now I find all sorts of persons. There is a chaiwala who is coming to my office in the evening. He has got this card where this QR code is there. So this QR code is shown, and I show my mobile phone to him. He gets money. So likewise, you go to even my native place. I went there. About 250 kilometers from Kochi. So we are people who pluck coconuts, and it's a source of income for large number of Keralites. Now the fellow who's going to pluck coconut, he is paid by Google Pay. He'll give you his number, you give it to him. Now our economy is largely slaved by this digital. Now suppose, assume this economic stability of a country is damaged, not by just throwing one bomb or two bombs, nothing will happen to, or just burning a building or something. But if you damage the economy, that would be the biggest terrorist activity. Your entire act. So that has been made specifically an offense in section 113. Now one criticism which is regarding the repeal and savings provision, because they say it gives rise to a lot of confusion. I believe it does not, because you find that when the 1898 code was repealed by the 1973 code, because 1973 code came to separate the judiciary from the executive completely. Article 50 of the Constitution mandates that judiciary should be separate from the executive. Now you find that 1973 code was primarily meant for that, and you find executive magistrates on one side, judicial powers being granted to judicial magistrates, and then 484 provided repeal and savings provision in the earlier code. Now we find in the Bharatiya Sakshya Niyam, the repeal and savings provision 531 actually has reproduced 484, which there are several Supreme Court decisions on this old 484, which is largely in tune with, I shall just quote certain judgments, which one is Boscher Pierre Andre versus Superintendent of Jail, that is relating to 428 set-off. So a person is entitled to set-off in our, suppose he, as an under trial, he spends some time in jail, and then finally he is convicted, and he is entitled to get this period spent as an under trial set off when he is finally convicted. The Supreme Court said, interpreting this 428, they said that the section is not given retrospective effect. The section operates prospectively on the sentence which yet remains to be served. So suppose a sentence is given, he is to serve the sentence. So you look at that sentence. So this section, Supreme Court said, operates prospectively, and therefore he is entitled to set off. Now the next section is, they said that is pertaining to 482 and 399(3) regarding the revision application. Whether the question was whether a revision petition filed under 399(3) before the High Court is an application or not, and what should be the law dealing with that. They held that that is also an application, and if it is filed after the 1973 code, it will have to be decided as per the 1973 code, and if it is pending at the time when the code is introduced, it will have to be decided in accordance with the old code. There is no room for confusion. Now 77 Supreme, there is another decision, you all remember the Nanavati's case. In Nanavati's case, despite the judge, formerly we all had jury trial. So jury, just like in the Western countries, we used to have jury trial, and the judge sums up the evidence and gives instructions to the jury. Judge decides on the admissibility of evidence, and jury finally are the fact-finding authority. Now, in Nanavati's case, despite the judge's instruction to find whether it is a culpable homicide or murder, that was the only question which had to be decided by the jury, but jury acquitted it. So it was, judge reversed then it was later reversed, the finding was reversed in appeal, and the jury trial was abolished by the, after that decision, in our country, we abolished jury trial. Now, the provisions relating to jury trial is not found in the 1973 code. And before that, in committal proceedings, the magistrate had to frame charge and then send it up for, send it to the court for trial, to the sessions court. But then, after the 209 and the new provisions of the 1973 code, the magistrate is something in the nature of a post office. He has to see whether the packet is in order, and he cannot invoke 319 except at the stage of taking cognizance. After taking cognizance, he has to send the file, no framing charge, nothing, no discharge, because formerly under the old code he could do all these things. Now this question was answered. This question was answered by the Supreme Court in state of Karnataka versus Annegowda. And then there is the 1979 decision. So all these matters which we find that there is some doubt regarding the provisions of relating to repeal, that has been dealt with by the Supreme Court in the earlier, under the earlier code, 484, they have considered these matters in depth and have rendered judgments. And there is no room for confusion, because what the new code has done is, rightly, they have extracted the old repeal and savings provision in the new Bharatiya Nagarik Suraksha Samhita. Now I have so I am running two. One thing is, everyone is waiting eagerly for lunch, and I am just boring you with this peroration regarding Bharatiya Nagarik Suraksha Samhita and the other, which Justice Bagchi has comprehensively dealt with. Now, because whatever he has dealt with, I don't want to go into, because that would create only further, it will be a perpetual ennui. Now the Bharatiya Nyaya Samhita now makes the organized crime has been defined, and organized crime is specifically an offense in this. Organized crime means a group of two or more persons who acting singly or jointly as syndicate or a gang indulging in any continuing activity. Now there are several organized gangs in our country which are loosely known as mafiosis. Mafia is a word which emerged from Sicily, and then it traveled to America. An American mafiosi, the most famous novel is Mario Puzo's Godfather, which was made into a movie, and it has got two other movies after that, Godfather 2 and 3. Now, people all watch these. We have also in our midst gangsters and organized crime. But then this organized crime is a fact of life, as we know about terrorist offense in the modern days. There are organizations. Now, organization contains a lot of persons. A foot soldier may be doing something, but he will be doing at the command of the person who is sitting at the top. And then to curb these kind of offense, protect the people, we have to have a proper investigation and a proper definition for this organized crime. That you will find in 111. 111 says any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, trafficking of persons, drugs, weapons, or illicit goods or services, human trafficking for prostitution, or ransom by person or a group of persons acting in concert. These are all made part of the offense of organized crime syndicate. Organized crime syndicate is defined as a group of two or more persons who acting either singly or jointly as a syndicate of gang to indulge in any of these continuing activities. So far as organized crime is concerned, it is a continuing activity. And economic offenses conducted by this organized syndicate include various aspects, because so far as counterfeiting is concerned, other economic crimes are concerned, these are all conducted by a group of persons with one person at the helm of the affairs, or two or more persons at the helm of the affairs, and their tentacles going into the society and then threatening people. Now, suppose somebody commits an organized crime and a person is a witness to that. He is unable to utter because another person will be the one person who is doing that contract killing for the organized criminal. Now, this BNS has taken care of all this. Now, this is what stated by Oliver Wendell Holmes, one of the celebrated judges of United States Supreme Court. That is a felt necessity of time. Felt necessity of time. These are all terrorism, making it an offense, making organized crime an offense, giving it a specific definition, are all we understand felt necessity of time. Now I had, my grandfather had a dictionary, English dictionary. So I still have it. It is a very old one. If you open that, there is no word hijack in that. Hijack was not known to them because nobody used to travel in plane. People used to go in horseback. And also Macaulay also used to go in, horseback. Horse riding was this. Now, people criticize the Bharatiya Nyaya Samhita because there are some references to horses. There is nothing wrong if you refer to a horse. They just did not refer to a motor car. So, nonetheless, horse is also, it's only a symbol to explain misappropriation, the symbol to explain negligence and all that. We need not, because this is very pithily explained in those illustrations by Macaulay, law does not change whatever is stated in those illustrations. Now I must say that if you criticize this, you are going back on syllogism. Life of law is not syllogism. So the felt necessity of time has been, when we look at all these provisions, we find that that has been dealt with by the BNS to a great large extent. Now you find another thing is, we have this POXO Act, we have several other enactments, Income Tax Act, where you find provisions of reverse burdens and provisions pertaining to, impairing the presumption of innocence to an extent, especially in POXO. But the framers, I should say, have taken care not to introduce these provisions of reverse burdens, except which were there extant in the old Indian Evidence Act. So that also you can see the presumptions like which Justice Bagchi had pointed out, 113, that is gang rape relating to consent. That is retained in this section also, but that is only proper. Now the definition of consent, again, judicial decisions say what consent is. Consent means in the case of rape or yes, it is not a passive, non-resistance does not amount to consent. It is all well settled matters. So I am not going into those areas because Justice Bagchi has taken us to all those matters. Now, so what I have to say is that we are a government of laws, not a government of men. In fact, Richard Posner, in his book How Judges Think, after all I think, except for police officers also sometimes think like judges because they are guided by the evidence laws and other things. So, Richard Posner is a celebrated judge in America. He has written a lot of books. In his book How Judges Think, he says, he quotes Ivan Karamazov in Karamazov Brothers. He says, if God does not exist, everything is permitted. If God does not exist, everything is permitted. He says, saying that we are a government of laws and not men. The rule of law is what guides us. And if there is no law, there is nothing to prevent judges from doing what they like. So law is the most important thing. And law's empire, which is stated by John Rawls, should not shrink, should not be allowed to shrink. How do we do that? We do that by conferences like this, to educate ourselves regarding the necessity of undergoing a thorough evaluation of new laws and the old laws. Oliver Wendell Holmes also says that in order to know what law is, we must know what it has been and what it tends to become. We must alternately consult history and existing theories of legislation. So, but the most difficult labor will be to understand the combination of the two into new product at every stage. So every stage when new law comes, one of the best things we can do is analyze the provisions in conferences like this, keep on educating ourselves regarding the changing laws. And finally, I must say, I thank the organizers of this function, and especially Chief Justice, for inviting me to spend some time with you discussing the three laws. And I think my time is up. It is almost 2 o'clock. Thank you for patiently listening to me at this late hour of the day. Thank you.
Thank you so much, Honorable Senior Advocate Shri B.G. Harindranath sir, for sharing your important views with us. With this, we end this session, second session, and now we will have a lunch break, 45 minutes of lunch break. Now it is 1:52, we can calculate 1:55. By 2:40, you are requested to be here in the hall for our next session, third and fourth session. So I request all of you to please proceed outside the auditorium, and the lunch is waiting for you all. After lunch break at 2:40, we will meet here again. So please be on time. And now मिलते हैं ब्रेक के बाद 2:40 में हम लोग फिर से लंच ब्रेक के बाद यहाँ उपस्थित होंगे अपने 3rd और 4th सेशन के लिए, और उसमें हमारे गेस्ट स्पीकर आएंगे अपने व्यूज़ को लेकर आपके बीच। तो 45 मिनट का हमारा लंच ब्रेक है। आप सभी से अनुरोध है कि ऑडिटोरियम के बाहर लंच की व्यवस्था की गई है आप सभी के लिए, आप सभी लंच कर लें। थैंक यू सो मच। We have two more sessions, third and fourth, and in the third session, our guest speaker is Mr. Neeraj Tiwari, Assistant Professor, National Law University, Delhi. And in the last session, and fourth session, our guest speaker is Shri Bhrigu Srinivasan Sir, Director, Bihar Police Academy, Rajgir. Sir, should I start? Okay. Thank you, sir. I would like to request, please take your seats. Before I introduce Dr. Neeraj Tiwari, before you, National Law University, Delhi. He is the guest speaker of the third session. A short introduction about Dr. Neeraj Tiwari. He served as a faculty at Hridayatullah National Law University, Raipur, and National Judicial Academy, Bhopal. At National Law University, Delhi, he is teaching criminal procedure law at undergraduate and postgraduate levels. He has worked as a senior faculty in the Committee for Reforms in Criminal Laws, CRCL, constituted by the Ministry of Home Affairs to suggest reforms in criminal laws. He has been engaged as a consultant by the Ministry of Home Affairs to carry out the work related to the three major criminal law bills. He has been associated with the UGC's PG Pathshala project on the subject Law and Criminology in the capacity of paper coordinator and successfully coordinated two courses on criminal justice administration and penology, and his MOC on criminal justice administration is one of the leading courses on the SWAM portal. He has lectured on various criminal law related issues at different forums like National Judicial Academy, Delhi, Judicial Academy, Rajasthan, Judicial Academy, Bihar Judicial Academy, Bureau of Police Research and Development Police, and Paramilitary Training Program, Faculty Development Program. His doctoral work on role of magistracy at pre-trial stage under the Indian criminal justice system. May I have the honor to invite our guest speaker of third session, Mr. Neeraj Tiwari, Assistant Professor, National Law University, Delhi. Sir, please.
Thank you so much. लंच के बाद के सेशन में देखता हूँ कहाँ तक मैं सक्सेसफुल हो पाता हूँ आपको जगाए रखने में, और आपके समक्ष दूसरी बार उपस्थित होने का मौका मिला है। एक बार कानून आने के पहले और दूसरी बार इस कानून के लगभग 1 महीने पुराने होने के अंतराल पे आपसे मिलने का मौका है। तो काफ़ी कुछ होगा जो हमने पिछली बार चर्चा करी, अगर आप उसमें थे तो आपकी तरफ से अब सुनने का भी अवसर प्रदान होगा कि क्या चैलेंजेस हैं या किस तरीके से ये जो नया कानून है उसमें क्या आपको दिक्कतें आ रही हैं, और उन दिक्कतों को समझने के साथ साथ उसका क्या सॉल्यूशन हो सकता है उस पर भी चर्चा करेंगे। और मैं धन्यवाद देना चाहूँगा माननीय मुख्य न्यायाधीश का और तमाम न्यायमूर्तिगण का, और साथ ही साथ तमाम ऑफिसर्स का जो इस सभागार में उपस्थित हैं। पीपीटी के माध्यम से मैं नए कानूनों पर चर्चा करना प्रारंभ करूंगा, और अगर बात करें एक नए कानूनों में जो ये बदलाव हुए हैं अब तो इनको अगर समझा जाए तो एक विशेष रूप से इस पे बल दिया जाना जरूरी है कि क्या इसमें कुछ जल्दीबाजी हुई या कितना समय दिया गया, किन लोगों से डिस्कशन हुआ इस पे, कहाँ से फीडबैक आए, सजेशंस आए। तो एक स्लाइड के माध्यम से मैंने इस चीज़ को इसमें रखा है कि जो ये कानून बना है इसको बनाने में जो समय इसमें लगाया गया है वो लगभग 4 साल 3 महीने और 17 दिन का है, जहां
इसकी जो पृष्ठभूमि जहाँ से शुरुआत हुई और जहाँ पे ये 25 दिसंबर 2023 को ख़त्म होता है, जहाँ पे प्रेसिडेंशियल जो एसेंट मिला तीनों ही कानूनों को पार्लियामेंट से पास होने के बाद। तो अगर आप देखें तो इस तरीके से इसका प्रोग्रेशन है इस नए कानून का, तीनों नए कानूनों का। और इस नए कानून में दो चीज़ इंपॉर्टेंट है। पहला, इसमें एक कमेटी की स्थापना की गई थी जिसको कि 3 मार्च 2020 को स्थापित किया गया और फरवरी 28, 2022 को कमेटी ने अपनी रिपोर्ट गृह मंत्रालय को सौंपी। साथ ही साथ इसके कमेटी द्वारा जो दिए गए सुझाव थे और बाकी और भी जो सुझाव थे उन सब पे फिर मंत्रालय के स्तर पे चर्चा हुई और उसके बाद जो बिल तैयार किए गए 11 अगस्त 2023 को जब उन्हें संसद के पटल पे रखा गया, तो जैसा आपको ज्ञात है कि उसी दिन उसको फिर डिपार्टमेंट रिलेटेड जो कमेटी है गृह मंत्रालय की, उसको भेजा गया और उस कमेटी ने 3 महीने का समय लिया और तीनों ही बिल पे अपनी जो रिकमेंडेशंस हैं उनको फिर गृह मंत्रालय को वापस भेजा और पुनः फिर पहले के जो 3 बिल थे उनको फिर विड्रॉ किया गया और 3 जो नए कानून, जिसको कि अगर आप पढ़ें तो जब दोबारा ये कानून संसद में लाए गए तो ये द्वितीय नाम से लाए गए, भारतीय न्याय द्वितीय संहिता, भारतीय नागरिक सुरक्षा द्वितीय संहिता, भारतीय साक्ष्य द्वितीय बिल, इस नाम से लाए गए और 20 और 21 दिसंबर को उन्हें संसद में पारित किया गया दोनों सदनों से और 25 दिसंबर को फिर उसमें फाइनली प्रेसिडेंट की एसेंट मिली। एक छोटा सा बॉक्स है जो एग्जॉस्टिव नहीं है किसी भी मामले में, लेकिन ये दर्शाता है कि कहाँ से किस तरीके के सुझाव, कितने सुझाव आए। केवल एक ग्लिम्स है उसका, ये पूरा जो सुझावों का जो भंडार है उसको नहीं दर्शाता है, पर ये जरूर बताता है कि जो पार्टिसिपेशन था, भागीदारी थी, उसमें कौन लोग शामिल थे। तो अगर आप न्यायालय की तरफ देखें तो माननीय उच्चतम न्यायालय के साथ साथ उच्च न्यायालय के साथ साथ नेशनल जुडिशियल एकेडमी, स्टेट जुडिशियल एकेडमी, नेशनल लॉ यूनिवर्सिटीज, मेंबर ऑफ पार्लियामेंट और तमाम लॉ इन्फोर्समेंट एजेंसीज जो हैं सीबीआई, एनआईए, ईडी, इनसे भी इस पर सुझाव आए। यहाँ तक कि सुझावों की संख्या इतनी थी कि उनको अगर देखा जाए तो सिविल सोसाइटीज, एनजीओ के साथ साथ लॉयर्स के भी सुझाव आए। तो कई सुझावों के साथ इस नए कानूनों को बनते हुए देखने का अवसर मुझे प्राप्त हुआ जब मिनिस्ट्री के द्वारा जो स्थापित कमेटी थी उसमें मुझे कार्य करने का अवसर मिला। उसके बाद अभी भी मैं मिनिस्ट्री से जुड़ा हुआ हूँ एज ए कंसल्टेंट, पहले ड्राफ्टिंग के पार्ट पे और अब इम्प्लीमेंटेशन के पार्ट पे, इन तीनों कानूनों पे। तो जो बड़े बदलाव हैं अगर उनको समझें, क्योंकि अब तक तो काफ़ी चीज़ें आपके पास पहुँच चुकी होंगी, लेकिन जो समझने वाली बात है कि किस तरह का बदलाव का स्वरूप क्या है, विस्तार क्या है और क्या बदल गया है जिसको कि अब नए कानून के आने के बाद छोड़ना है और क्या ऐसा है जिसको कि अब नए कानून के आने के बाद समझना है। तो ये जो भारतीय न्याय संहिता में जो कुल बदलाव है उसको दर्शाता है, जिसमें कि कुल 190 छोटे बड़े बदलाव किए गए हैं। बदलाव के स्वरूप अगर देखें तो मुख्य रूप से 3 हैं। पहला, अपराधों को निरस्त किया गया है, नए अपराधों को जोड़ा भी गया है जिनकी संख्याएं अलग अलग हैं। साथ ही साथ सजा में एक बदलाव किया गया है जिसमें सजा को बढ़ाया गया है, जुर्माने की राशि को बढ़ाया गया है और इसके साथ साथ अगर देखें तो मैंडेटरी मिनिमम सजा भी लाई गई है। और जो सबसे बड़ा बदलाव जिसपे जस्टिस बागची ने भी प्रकाश डाला और उसके पहले इनॉग्रल सेशन में भी उस पर चर्चा हुई, कम्युनिटी सर्विस को लेके, उसको भी नए कानून में जगह मिली है पहली बार। जो डिटरेंस की थ्योरी है, रिट्रीब्यूशन की जो थ्योरी है, उससे एक कदम आगे बढ़ते हुए जो सुप्रीम कोर्ट और डिफरेंट हाई कोर्ट्स की जो एक रिफॉर्मेटिव अप्रोच है पनिशमेंट की, उसको भी ये नया कानून दर्शाता है, जिसमें कि नाम में ही चूंकि न्याय छुपा हुआ है तो न्याय के साथ जो कम्युनिटी सर्विस है उसमें इस न्याय को देखने को मिलता है, जिसके द्वारा अब सजा जेल के अलावा जेल के बाहर भी जो कम्युनिटी सर्विस है उसके माध्यम से दी गई है। साथ ही साथ अगर देखें नागरिक सुरक्षा संहिता में क्या बदलाव हुए हैं, तो बदलाव का स्वरूप अगर नागरिक सुरक्षा संहिता का देखें तो ये काफी व्यापक है और तीनों ही कानूनों में सबसे ज्यादा व्यापक जो बदलाव हुए हैं वो नागरिक सुरक्षा संहिता में हुए हैं। और मेरे ख्याल से यहाँ बैठा हुआ हर व्यक्ति नागरिक सुरक्षा संहिता से जुड़ा हुआ है, उसके क्रियान्वयन से जुड़ा हुआ है। तो ये जानना बहुत जरूरी है कि ऐसे क्या बदलाव है जो नागरिक सुरक्षा संहिता पे मैं कई बार हो सकता है कि ओवरलैपिंग हो, जो पहले ही एमिनेंट स्पीकर्स ने जिस पर चर्चा करी है उस पर मेरी भी बात हो उस पर, लेकिन मैं उसको कम करके उस चीज को सामने लाऊंगा कि अब इनमें जो बदलाव हुए हैं उनमें कहाँ क्या दिक्कतें हो सकती हैं या क्या उससे सुधार या उससे कौन सी ईज आई है प्रोसीजर, प्रोसेस और सिस्टम में। तो अगर भारतीय नागरिक सुरक्षा की बात करें तो 360 बदलाव 177 प्रावधानों में देखने को मिलते हैं भारतीय नागरिक सुरक्षा संहिता के द्वारा। कुल अगर देखें तो इसमें दो बड़ी इंपॉर्टेंट चीज हैं, जो लास्ट के जो अगर नीचे से देखें तो जो तीसरा और फिर दूसरा पॉइंट है, जहां 39 जगहों पे 39 प्लेसेस में ऑडियो वीडियो इलेक्ट्रॉनिक मीन्स का इस्तेमाल किया गया और 45 जगहों पे टाइमलाइन का इस्तेमाल किया गया है। तो ये दोनों ही किसी वजह से लाए गए एक साथ। तो अब जो टाइमली और स्पीडी जस्टिस का जो कॉन्सेप्ट है उसमें दो टी बड़े इंपॉर्टेंट हैं, टेक्नोलॉजी एंड टाइमलाइन। तो टेक्नोलॉजी और टाइमलाइन का जो ये एक फ्यूजन है वो इस नए कानून में है। यहाँ पे जो समयावधि है वो बिना टेक्नोलॉजी के नहीं है, जहां भी समय से बांधा गया है प्रोसेस को या प्रोसीजर को, वहां पे उसको टेक्नोलॉजी से भी जोड़ा गया है। तो टेक्नोलॉजी के माध्यम से वो समय सीमा प्राप्त होती हुई दिख सकती है इस नए कानून में, जिस पे हम चर्चा करेंगे। और अगर बात करें तो देखें तमाम सब सेक्शंस की संख्या कितनी ज्यादा है वो जोड़ी गई है, और प्रोविजोज और एक्सप्लेनेशन जो 49 के आसपास हैं उनको भी इसमें जोड़ा गया है। साक्ष्य अधिनियम पे चर्चा हुई इससे पहले वाले सेशन में, उसमें पता चला कि किस तरीके से नए कानून में अब इलेक्ट्रॉनिक एविडेंस को लेकर एक बड़ा बदलाव किया गया है। तो तीनों ही कानूनों में सबसे कम अगर विस्तार है बदलावों का तो वो साक्ष्य अधिनियम में है। 170 धाराएं हो गई 167 धाराएं से बढ़ के, और साथ ही साथ इलेक्ट्रॉनिक एविडेंस से जुड़ी जो दो धाराएं हैं 57 और 61 वो बड़ी इंपॉर्टेंट है, जिसपे की चर्चा होना जरूरी है आज या कल जिस भी सेशन में। तो इस तरीके से ये बदलाव दिखाता है भारतीय न्याय संहिता के साथ साथ सुरक्षा संहिता के साथ साथ अब साक्ष्य अधिनियम में। जो बदलाव है उसको इस तरह से देखें अगर तो समझना थोड़ा सा आसान होगा कि क्या सब कुछ बदला है या बदला जाना चाहिए, तो उसका उत्तर तो नहीं है, क्योंकि अगर पूरा सिस्टम ही अपसाइड डाउन हो जाएगा तो उसका तो फिर उसमें तो सिस्टम को चलाना बड़ा मुश्किल हो जाएगा। तो इसलिए इस बदलाव को चेंज विद कंटिन्यूटी की तरह देख सकते हैं। निरंतरता और बदलाव दोनों हैं इसमें। तो क्या कंटिन्यूएशन किस चीज का है और क्या बदली हुई चीजें हैं उसको समझने का प्रयास करें अगर इन कानूनों के माध्यम से, तो सबसे बड़ा बदलाव तो यही है कि अब ये जो नया कानून है ये ज्यादा सिस्टमटाइज्ड है और इसमें जो प्रोविजंस हैं या चैप्टर्स हैं उनको रीऑर्गेनाइज किया गया है। तो ये एक बड़ा बदलाव है जो भारतीय न्याय संहिता में ज्यादा अच्छे से देखने को मिलता है, जो कि भारतीय न्याय संहिता जिसमें पहले कुल अगर हम देखें तो चैप्टर्स 23 के आसपास थे वो 20 हो गए हैं, धाराएं 511 से घट के 358 हो गई हैं, नए चैप्टर्स भी जोड़े गए हैं, चैप्टर 4 चैप्टर 5 दोनों नए चैप्टर्स हैं। तो इस तरीके से जो चैप्टर्स हैं और प्रोविजंस हैं दोनों को ही नए कानून में बदला गया है। और क्या बदला है दूसरा अगर देखें तो जो फोकस एरिया है कानून में उसको प्रायोरिटाइज किया गया है। 3 मुख्य अगर माने फोकस एरिया क्या हो सकते हैं, तो पहला तो विक्टिम है। तो विक्टिम को कानून में एक जगह मिली है, चाहे वो न्याय संहिता हो या नागरिक सुरक्षा संहिता हो। साथ ही साथ एक्यूज्ड को अगर देखें तो उसको भी वरीयता मिली है। किस तरह के एक्यूज्ड को? फर्स्ट टाइम ऑफेंडर को। पहली बार कानून में फर्स्ट टाइम ऑफेंडर को चाहे वो न्याय संहिता हो या नागरिक सुरक्षा संहिता हो उसमें एक बेनिफिशियल ट्रीटमेंट दिया गया है जिस पर हम चर्चा करेंगे। और उसी के साथ साथ जो हार्डन क्रिमिनल्स हैं उनको भी इस कानून ने फोकस एरिया में रखा है, जिनमें घोषित अपराधी जो है पीओ उसको लेके विशेष प्रावधान किए गए हैं 1 से अधिक स्थानों में भारतीय नागरिक सुरक्षा संहिता में। अब अगर बात करें कि कैसे इस तीनों कानूनों ने जो एक ब्रिटिश लीगेसी थी उसको छोड़ा है पीछे, तो जितने भी रेफरेंसेस थे कॉलोनियल एरा के उसको बिल्कुल ड्रॉप कर दिया है नए कानूनों में। तो उस पर ज्यादा अब जाने की जरूरत नहीं है, क्योंकि कानून आपके सामने है, आपने पढ़ा भी है। तो उसमें जितने भी रेफरेंसेस थे चाहे वो ब्रिटिश क्वीन हो या विक्टोरिया हो या कैलेंडर हो, जो भी इस तरीके से उनको फिर खत्म किया है इस नए कानून में। अब ये सिटीजन सेंट्रिक कैसे है, वेलफेयर एक मेजर क्यों है ये कानून? तो भारतीय न्याय संहिता के कुछ अपराध तो ऐसे हैं जो पूरी तरह से सिटीजन वेलफेयर, सिटीजन प्रोटेक्शन के लिए बने हुए हैं, चाहे वो पेटी ऑर्गेनाइज क्राइम हो या स्नैचिंग का ऑफेंस हो या सेक्शन 95 या सेक्शन 69 के जो 2 अपराध जिस पे चर्चा करी जस्टिस बख्शी साहब ने भी, अगर उसकी बात करें तो अब इनमें अगर देखें तो बहुत ज़्यादा ये सिटीजन सेंट्रिक अपराध बनाए गए, जहां नागरिक की सुरक्षा, उसकी संपत्ति की सुरक्षा की बात कही गई है। साथ ही साथ जो नेशन है उसको अगर देखें कैसे नया कानून प्रोटेक्ट करता है, तो 152 है जो एक्ट इंडेंजरिंग सॉवरेनिटी, इंटीग्रिटी, यूनिटी की बात करता है वो। साथ ही साथ 111 और 113 ऑर्गेनाइज क्राइम और टेररिस्ट एक्ट है, उसमें जो प्रावधान जोड़े गए हैं, जो अपराध बनाए गए हैं, वो कहीं ना कहीं जो नेशन है, राष्ट्र है, उसकी संप्रभुता, अखंडता और एकता उसको सुरक्षित करता है। मॉडर्नाइजेशन की जो बात कही गई है इस नए कानून में, जो चैलेंजेस थे टेक्नोलॉजी के, अब तकनीक के दो तरीके के चैलेंज हैं। तकनीक का इस्तेमाल अपराध करने में होता है और अपराध को सुलझाने में भी होता है। तो नए कानून ने दोनों ही तरीके से तकनीक को इसमें शामिल किया है। जहां पे अपराध करने में टेक्निक का इस्तेमाल हो रहा है, टेक्नोलॉजी का इस्तेमाल हो रहा है, तो कई ऐसे अपराध हैं जहां उनको लिखा गया है कि अगर ये अपराध इलेक्ट्रॉनिक मीन्स के माध्यम से भी किए जा रहे हैं तो वो अपराध की संज्ञा में आएंगे। साथ ही साथ टेक्नोलॉजी को एज अ मीन्स बनाया गया है अब उस अपराध को सॉल्व करने के लिए, और टेक्नोलॉजी को इस्तेमाल किया गया है ईजिंग द प्रोसेस ऑफ डिस्पेंसेशन ऑफ जस्टिस थ्रू आउट, उसमें भी इसको लाया गया है। तो जो कंटेम्प्रेरी चैलेंज जो टेक्नोलॉजी को लेके थे, उसको तीनों ही स्तर पे इस नए कानून ने एड्रेस किया है, चाहे वो अपराध को करने में हो या अपराध को सुलझाने में हो या अपराधी और पूरी सिस्टम जो है, प्रणाली है, उसको सुचारू रूप से चलाने में हो। तो इस तरीके से मॉडर्नाइजेशन की बात इस नए कानून में देखने को मिलती है। अब मुख्य बिंदु क्या है कि क्या कंटिन्यूड है, और ये जानना बहुत जरूरी है कि कंटिन्यूड जो चीजें हैं वो कौन सी हैं। अभी सुबह बात हुई कि किस तरह से जो रोमन लॉ है या रोमन मॉडल है या जो फ्रेंच मॉडल है, जिसको इंक्विजिटोरियल सिस्टम भी कहते हैं, उसकी तरफ नया कानून नहीं गया। जबकि आप सबको विदित है, ज्ञात है कि आज से 2 दशक पूर्व जस्टिस वीएस मालिवत कमेटी की रिपोर्ट आई थी 2003 में, जिसमें कि फ्रेंच मॉडल जो था उसको अडेप्ट करने की बात कही गई थी, क्योंकि उससे कन्विक्शन रेट को बढ़ता हुआ देखा जा रहा था। उस कमेटी की रिकमेंडेशन है, अगर पढ़ें तो, कि किस तरह से टाइम हैज कम फॉर इंडिया टू शिफ्ट फ्रॉम एडवर्सेरियल टू इंक्विजिटोरियल जस्टिस डिस्पेंसेशन मॉडल टू इनहेंस द लो कन्विक्शन रेट का जो कंसर्न था उसको एड्रेस करने के लिए। अब अगर बात करें क्या वो सुझाव इस नए कानून के बनते समय नहीं थे, तो बिल्कुल थे, उस पर चर्चा भी हुई, लेकिन ये पाया गया कि जो एग्जिस्टिंग सिस्टम है, एडवर्सेरियल सिस्टम, वो ही अभी गिवन टाइम में, मौजूदा समय में एक बेहतर सिस्टम है, और विद इन दिस सिस्टम किस तरीके से इसको बेहतर बनाया जा सकता है उसकी बात इसमें कही गई, इसीलिए इसको कंटिन्यू किया गया। तो देयर इज नो शिफ्ट फ्रॉम एडवर्सेरियल टू इंक्विजिटोरियल मॉडल, जो एडवर्सेरियल सिस्टम है उसी को इसमें चलाया गया है। दूसरा, अगर बात करें एपेलेट जुडिशियल स्ट्रक्चर की, एक ये भी कंसर्न था कि क्या अपील की अब जो स्कोप है उसको खत्म किया जाएगा। कुछ केसेस केवल हाई कोर्ट के स्तर पे ही खत्म हो जाएंगे, सुप्रीम कोर्ट तक नहीं जाएंगे। तो इस बात को भी जानना बहुत जरूरी है कि अपील में सिवाय एक छोटे से बदलाव के मुख्य रूप से अपील के स्ट्रक्चर में कोई बदलाव नहीं किया गया है। कानून में जिस तरह से केस का प्रोग्रेशन होता था उसी तरह केस आगे बढ़ेगा, उसमें कहीं कोई बदलाव नहीं किया गया है। अब जो अगला बिंदु है, अगर उस पर थोड़ा सा ध्यान दें, वो बहुत इंपॉर्टेंट है। वो इसलिए इंपॉर्टेंट है क्योंकि भारत में अब जो कानून अगर देखें, जो स्पेशल पिनल लॉ की कैटेगरी के अपराध हैं या फिर कानून है, चाहे वो एनडीपीएस हो, पीएमएलए हो, यूएपीए हो, आर्म्स एक्ट हो, पॉक्सो हो, एससी एसटी प्रिवेंशन ऑफ एट्रोसिटीज हो, तमाम जो भी अपराध से जुड़े हुए स्पेशल लॉज हैं, उनमें कुछ एक्सेप्शंस हैं जो फाउंडेशनल प्रिंसिपल्स हैं हमारे जनरल क्रिमिनल लॉ के। अगर हम देखें तो कई अपराध जो ये है कानून है, स्पेशल लॉज हैं, उनमें एक रिवर्स ओनस की बात करते हैं, रिवर्स बर्डन की बात करते हैं, जहां बर्डन शिफ्ट हो जाता है प्रोसिक्यूशन से एक्यूज के ऊपर। दूसरा, उसमें बढ़ी हुई एक अवधि है पुलिस कस्टडी की। तीसरा, टोटल कस्टडी पीरियड भी बढ़ा हुआ है, 180 दिन, किसी कानून में 1 साल तक की अवधि है। चौथा, बेल जो है वो नेक्स्ट टू इम्पॉसिबल है, चाहे वो यूएपीए हो या पीएमएलए हो, जैसा हमने देखा, और एनडीपीएस। ऑनरेबल सुप्रीम कोर्ट ने भी कुछ दिन पहले भी ये बात कही कि स्पेशल लॉज में भी बेल जो है वो व्यक्ति का अधिकार है, और उस अधिकार का हनन तब तक नहीं हो सकता जब तक कि कोई प्रोसीजर ड्यू प्रोसेस को मैच नहीं करता है या उस स्टैंडर्ड को मीट नहीं करता है। अब ये सारी चीजें थी, तो क्या नए कानून में ये चीजें बदली? तो ये जानना बहुत जरूरी है कि जो जनरल क्रिमिनल लॉ है, जिसमें ये तीनों मेजर एक्ट्स आते हैं, आईपीसी, सीआरपीसी और एविडेंस एक्ट के बाद जो नए 3 कानून हैं, बीएनएस, बीएनएसएस और बीएसए, इन तीनों ही कानूनों में इस चीज को लेके कोई डिपार्चर नहीं है। अभी भी कानून प्रिजम्पशन ऑफ इनोसेंस को ही लेके चलता है, प्रिज्यूम्ड टू बी इनोसेंट अंटिल प्रूवन गिल्टी, burden lies on the prosecution and the standard of proof is the same beyond reasonable doubt। उसको भी डाइल्यूट करके सिविल लॉ का जो स्टैंडर्ड है उसको नहीं रखा गया है। तो ये तीनों चीजें ये दर्शाता है कि कहीं ना कहीं नए कानून, जो सुबह भी चर्चा हुई कि किस तरह से आर्टिकल 21 में जो लाइफ और लिबर्टी का जो अधिकार है उसको प्रोटेक्ट करते हुए दिखते हैं, उसी की तरफ ये आगे बढ़ते हुए दिख रहे हैं इसके माध्यम से भी। अब बात करें कि जुडिशियल इंटरप्रिटेशन जो तमाम धाराओं को, प्रावधानों को अभी तक दी गई है, क्या उनके स्थान बदलने भर से क्या वो खत्म हो जाएंगे और फ्रेश इंटरप्रिटेशन की जरूरत पड़ेगी? तो उस पर भी मेरा जो मानना है वो यही है कि ऐसा बिल्कुल नहीं है। 420 318 हो गई अगर नए कानून में, तो उसके स्थान बदलने से जुडिशियल इंटरप्रिटेशन बदल जाए, ऐसा नहीं है। 302 103 1 हो गया नए कानून में, तो उससे भी कोई बदलाव से कुछ ऐसा नहीं। हाँ, तो ये समझे कि कोई भी अपराध 2 चीजों से बनता है। एक तो हो गया उसका डेफिनेशनल पार्ट जो उस अपराध को डिफाइन करता है, और दूसरा उसका पनिशमेंट पार्ट। तो जहां तक पनिशमेंट का सवाल है, तो लगभग हर अपराध मेजरली उसमें पनिशमेंट किसी न किसी रूप से बदली गई है, घटाई गई है, बढ़ाई गई है, नई जोड़ी गई है, इस तरीके से। लेकिन जहां तक उसका जो डेफिनेशनल पार्ट है, जो उस अपराध को परिभाषित करता है, वो अगर नहीं बदला है किसी भी अपराध में, तो उसमें जो जुडिशियल इंटरप्रिटेशन सुप्रीम कोर्ट और हाई कोर्ट ने दी है वो वैसी ही रहेंगी, उनमें कोई बदलाव नहीं आएगा। ये समझना बहुत जरूरी है। लास्टली हम देखें तो क्या एक चीज और है बड़ा इंपॉर्टेंट, जो चैप्टर था एक डिफेंसेस का आईपीसी में, उसको भी नए कानून में रिटेन किया गया है, भारतीय न्याय संहिता में बदला नहीं गया है। तो अब उस तरीके से अगर समझे उसको, तो क्या उसमें कोई बदलाव है? अब एक प्रश्न मैं आपकी तरफ छोड़ता हूं, उसका उत्तर हम आखिरी में लेंगे या कल लेंगे जब ओपन हाउस डिस्कशन होगा तब, कि अगर जो जनरल डिफेंसेस का चैप्टर है, आईपीसी में भी था और भारतीय न्याय संहिता में भी, उसको पढ़ें तो उसमें लिखा हुआ है कि हर व्यक्ति को जो डिफेंस है वो एक्सरसाइज करने का राइट है 2 सिचुएशन में, जहां प्रॉपर्टी खतरे में है उसकी, और जहां या तो उसकी बॉडी खतरे में है। तो दोनों लिखा हुआ है, एनी ऑफेंस अफेक्टिंग बॉडी, एनी ऑफेंस अगेंस्ट प्रॉपर्टी। अब चूंकि ये तब तक तो सही था जब तक रेप जैसे अपराध बॉडी वाले चैप्टर में थे, चैप्टर 16 आईपीसी में, तो 375 76 ABC जो भी थे सब उसी में थे। अब चूंकि उनको वहां से हटा लिया गया और एक नया चैप्टर 5 बनाया गया, तो राइट जो क्राइम या ऑफेंस अगेंस्ट वुमेन एंड चाइल्ड है, उनको अब चूंकि वहां से निकाल के अब एक नए चैप्टर में डाला गया है, तो क्या उनके वहां से हटने से भर से अब इन ऑफेंस में राइट टू प्राइवेट डिफेंस या ये सारे डिफेंसेस जो हैं, इंटॉक्सिकेशन, इंसैनिटी, मिस्टेक ऑफ फैक्ट, एज जो भी हैं, क्या वो लागू नहीं होंगे? क्योंकि जो मुख्य जो प्रावधान है अगर उसको देखें तो अभी भी वो 2 ही तरह के ऑफेंस की बात करता है, या तो ऑफेंस अगेंस्ट बॉडी अफेक्टिंग ह्यूमन बॉडी, या तो ऑफेंस अगेंस्ट प्रॉपर्टी। तो क्या इनके निकलने से अब इन अपराधों में जो डिफेंस का चैप्टर है जनरल डिफेंस का वो लागू नहीं होगा? तो इस पे हो सकता है कि थोड़ी सी जुडिशियल एक इंटरप्रिटेशन की आवश्यकता हो आने वाले समय में। लेकिन कानून बनाते समय इसका ये आशय बिल्कुल भी नहीं था कि उनको अगर एक नए चैप्टर में डाला जा रहा है तो उसका मतलब ये है कि उनमें ये डिफेंसेस एप्लीकेबल नहीं हो। एक तो ये चीज जरूरी है समझने के लिए। और इस कानून को समझने का जो तरीका है उससे समझ सकते हैं कि किस तरह से ये कानून, जो तीनों कानून है, वो एक स्ट्रांग स्टेट के साथ साथ एक ह्यूमन स्टेट की बात करता है। तो स्ट्रांग स्टेट में जैसा कि पहले बताया गया कि कैसे नए अपराधों का सृजन किया गया, चाहे वो ऑर्गेनाइज क्राइम हो, टेररिस्ट एक्ट हो, मॉब लिंचिंग हो, हिट एंड रन हो, इन सारे अपराधों को नए कानून में जोड़ा गया। और एक पनिशमेंट जो है उससे भी नए कानून में एक मजबूती लाने का प्रयास किया गया, जहां की बढ़ाया गया सजाओं को भी। सजाओं के बढ़ाने के साथ साथ एक इंपॉर्टेंट चीज और की गई कि पहले जो 2018 में जो आईपीसी में बदलाव किया गया, जिसके द्वारा माइनर जो गर्ल है उसके गैंगरेप में एक क्लासिफिकेशन किया गया कि 12 साल तक की बच्ची के गैंगरेप में मृत्युदंड की सजा थी उम्र कैद के साथ साथ, पर 12 से 16 साल की बच्ची के गैंगरेप में मृत्युदंड नहीं थी, केवल उम्र कैद की सजा थी। नए कानून में इस डिस्पैरिटी को, एज बेस्ड डिस्पैरिटी को खत्म किया गया। अब 18 वर्ष तक की बच्ची के गैंगरेप की सजा आजीवन कारावास के साथ साथ मृत्युदंड भी है। तो उसमें दो चीजें खत्म की गई, एक तो जो एज बेस्ड डिफरेंशिएशन था उसको हटाया गया और एक यूनिफॉर्मिटी एज को लाई गई और पनिशमेंट को भी यूनिफॉर्म किया गया उस एक्ट के लिए जो एक्ट कॉमन है दोनों ही सेट ऑफ इंडिविजुअल्स के लिए, चाहे वो 12 साल से कम हो या 12 से 16 साल के बीच की हो। अब वो 18 साल है नए कानून में और उसकी सजा मृत्युदंड और उम्र कैद दोनों है। तो ये बदलाव किया गया। पहली बार इस कानून में क्या लाया गया, तो अटैचमेंट ऑफ प्रोसीड्स ऑफ क्राइम, जो कि पीएमएलए का एक प्रोमिनेंट फीचर है, अब उसको इस नए कानून में भारतीय नागरिक सुरक्षा संहिता की धारा 107 में लाया गया है, जिसमें अब कोई भी ऐसी संपत्ति जिसको या तो डिराइव किया गया है या ऑब्टेन किया गया है किसी भी क्रिमिनल एक्टिविटी को करने से, तो नए कानून में अब पुलिस अपने सीनियर ऑफिशियल के द्वारा कोर्ट में एक एप्लीकेशन लगाकर कोर्ट के माध्यम से ऐसी संपत्ति की जब्ती कर सकती है, करवा सकती है। ऐसा प्रावधान नए कानून में किया गया है। ये एक बड़ा बदलाव है प्रोसीड्स ऑफ क्राइम को लेकर। साथ ही साथ अगर देखा जाए तो इन एब्सेंशिया ट्रायल, जिसमें जस्टिस बाकी सर ने भी कहा कि 356 जो भारतीय नागरिक सुरक्षा संहिता की धारा है, किस तरह से उसमें हुसैन वर्सेस यूनियन ऑफ इंडिया में सुप्रीम कोर्ट का जो ऑब्जर्वेशन है, और बाकी सर ने ये नहीं कहा कि उन्होंने खुद कादर खान के केस में खुद भी उस चीज को फिर फॉलो किया हुसैन के केस के बाद और उसको ऑब्जर्व किया कि होना चाहिए। तो दोनों ही तरीके से अगर देखें तो हाई कोर्ट के लेवल पे या सुप्रीम कोर्ट के लेवल पे कहीं ना कहीं प्रोक्लेम्ड ऑफेंडर को लेके, ऐसे अपराधी जो फरार हैं उनको लेकर जो एक ऑब्जर्वेशन था, नए कानून उसको भी लाया गया कि प्रोक्लेम्ड ऑफेंडर अब अगर विलफुली कोर्ट के समक्ष अपने आप को प्रस्तुत नहीं कर रहा है तो उसके खिलाफ फिर उसकी एब्सेंस में ट्रायल चलाया जा सकता है और अब वो घोषित अपराधी से कन्विक्टेड भी हो सकता है। उसके आने की जरूरत नहीं है, जिस पे हम चर्चा करेंगे आने वाले समय में। अब अगर बात करें ह्यूमन फेस क्या है इसमें, तो उस पर चर्चा हुई कि किस तरह से नए कानून में सारे वो अपराध जिनको निरस्त किया गया, चाहे वो 377 हो, 497 हो, 309 हो, 124A हो, सेडिशन, अटेम्प्ट टू कमिट सुसाइड, अडल्ट्री और अननेचुरल ऑफेंस, इन सबको नए कानून में खत्म किया गया। साथ ही साथ अगर बात करें जेंडर की डेफिनेशन को वाइड किया गया। अब जेंडर की डेफिनेशन नए कानून में बाइनरी से जुड़ी हुई नहीं है, मेल और फीमेल जो बाइनरी है, उसके बियॉन्ड जाके ट्रांसजेंडर को भी जेंडर के डेफिनेशन में लाया गया। और अगर बात करें किस तरीके से नए कानून में एक ह्यूमन फेस दिखता है, तो कम्युनिटी सर्विस और जो फर्स्ट टाइम ऑफेंडर है उनको लेके जो बदलाव किए गए वो ये दर्शाता है कि कानून ये दंड नहीं अब न्याय की तरफ बढ़ता हुआ दिख रहा है और वो दर्शाया गया भी है किस तरीके से इन